feels like a dream. They all come out in time. This week,
Nice to be retired. I'm involved in the retired, this is going to change, well, it's going to change the gears a little bit. I know, looking at the forecast, even next week's not going to be that great.
I don't know what the White Sox is with all the other teams.
This is really the kick things off. Okay.
How long?
Yeah, it's very strange.
I want you to, I didn't read I know, maybe that's right.
Two of these is a pattern of racketeering too.
Yes.
Yes.
Signature exercise. Will you be my guardian? Will you sign? Absolutely, my guardian. He's going to sign because it comes my guardian.
Yeah, there's actually some.
They never told us that we had to bring gifts. You know, I didn't know how many to buy for.
I got a couple quarters in my backpack.
Christian said I got a pack of gum, but it's not enough to go around.
We're gonna get started, so we're not too far off schedule. So. Morning, everybody. My name is Nathan Catanese, and I have the honor and privilege of serving as Editor-in-Chief of the Notre Dame Journal of Law, Ethics, and Public Policy. This year, we are hosting our symposium on the moral, ethical, and legal implications of white-collar crime in the 21st century. The Notre Dame Journal of Law, Ethics, and Public Policy is unique among law journals because it directly analyzes law and public policy from an ethical perspective. The journal strengthens Notre Dame Law School's moral and religious commitment by publishing articles, essays, speeches, and notes on legal, ethical, and policy considerations within the framework of the Judeo-Christian intellectual and moral tradition. Directed at an audience comprised of scholars, practitioners, and the general public, the journal publishes 2 issues annually. The journal devotes 1 issue to a single topic of public concern, this year, white-collar crime, and the other issue includes a variety of general topics related to the journal's mission. Contributors to the journal include legal scholars, judges, academics, practitioners, and student members of the journal. Before we move on, I would like to thank our co-sponsors for helping to make this event possible. Thank you to the National White Collar Crime Center, the Public Interest Law Forum, the Business Law Forum, the Notre Dame Department of Philosophy, and the American Constitution Society. I'd also like to thank the Student Bar Association of Notre Dame for their help in putting this together. So I know it's early, but you guys are in for a treat. We have a great lineup. And with that, I would like to now introduce our symposium editor, Adrian Stevenson. Adrian has done a terrific job organizing everything, and I'm looking forward to seeing everything and hearing everything. Thank you, Adrian.
Good morning. As Nathan said, my name is Adrian Stevenson, and I'm the symposium editor for this year. Thank you so much for coming out. I have the pleasure of introducing our moderator, Professor Jimmy Gurule. Jimmy Gurule is an internationally known expert in the field of international criminal law, specifically terrorism, terrorist financing, and anti-money laundering. He joined the Notre Dame Law School faculty in 1989, and in 1996 became a full professor. He served as Associate Dean for Academic Affairs in 1998 to 1999. He earned his bachelor's from the University of Utah in 1974 and his JD from the University of Utah College of Law in 1980. A member of the Utah State Bar since 1980, Professor Gurule has worked in a variety of high-profile public law enforcement positions, including as Undersecretary for Enforcement, U.S. Department of the Treasury, where he had oversight responsibilities for the U.S. Secret Service, the U.S. Customs Service, the Bureau of Alcohol, Tobacco, and Firearms, the Financial Crimes Enforcement Network, and many, many more. He was also the Assistant Attorney General at the Office of Justice Programs and Assistant U.S. Attorney, where he served as the Deputy Chief of the Major Narcotics Section of the Los Angeles U.S. Attorney's Office. Among his many successes in law enforcement, Professor Gurule was instrumental in developing and implementing the U.S. Treasury Department's global strategy to combat terrorist financing and engineered the conviction of those responsible for torturing and brutally murdering a Drug Enforcement Administration special agent in Mexico. So please join me in introducing Professor Gurule.
Thank you, Adrian. It's my pleasure to serve as a moderator for today's White Collar Crime Symposium. I'll be introducing the speakers, and then after each of the speakers have given their presentations, we'll be hosting a panel where I'll have an opportunity to ask the speakers a couple of questions, and then we'll open up the Q&A to the students. I think it's very important that the students have an opportunity to ask any questions of the speakers that they're interested in. And I think you're going to find today's presentation very interesting. I've had an opportunity to read all of the papers. I've learned a lot about white-collar crime in the process. I think it's a very substantive program. It's a very comprehensive program. Covers a great deal of material and issues with respect to white-collar crime. So with that, let me begin by introducing our first speaker, Dr. Cynthia Kohler. Dr. Kohler is an assistant professor of criminal justice at Shippensburg University and serves as the Criminal Justice Department's coordinator of the Pennsylvania Juvenile Court Judges Commission Graduate Education Program. She teaches a variety of undergraduate and graduate courses, including juvenile justice, criminological theory, white-collar crime, corrections, and justice administration and management. Her research interests include white-collar, international, and enterprise crime. Professor Blakey's ears perked when he heard that, enterprise crime. Diffusion theory, and juvenile justice. Dr. Kohler's book, White-Collar Crime in Housing, Mortgage Fraud in the United States, was recently published, and her work has appeared in the Criminal Law Bulletin and Economic Crisis and Crime. The title of her presentation is When Moral Reasoning and Ethics Training Fail, Reducing White-Collar Crime Through the Control of Opportunities for Deviance. And so with that, please give Professor Kohler a very warm Notre Dame welcome.
Good morning, everyone. Thanks for coming out so early. Special thank you to Angela and Adrian and Nathan for putting this all together, and all of the other different student groups that helped host this event, which I think is very important. This is something I'm very passionate about, and I'm sure you can attest to that because I talk nonstop about white-collar crime and how do we define it, how do we control it. But today I wanted to talk to you about how defining white-collar crime leads to understanding white-collar crime, leads to preventing white-collar crime, and really trying to get to the bottom of why do certain people commit crime in the workplace, but also how do systems become criminogenic. So my talk really relates to how an environment becomes so rampant with crime, and how we try to explain that. So what I'm using here today is an issue related to mortgage fraud, and we use in our article we talk about subprime mortgaging and how that came onto the scene 20 years ago or so and infiltrated the whole mortgage and housing finance system, and eventually people were able to take advantage of that, and talk a little bit about compliance and ethics. Trying to keep it within 20-25 minutes is a little bit difficult, but I did look at what some of the other speakers are going to be talking about, so I'll probably skip through some of these slides as we go forth. But to get started here, I really want to just give you a basic understanding of subprime mortgaging and the mortgaging industry itself, and that sets the premise for the further discussions. Subprime lending is an innovative tool that can be used to get particular people into the marketplace, into the housing industry that may not have been there before. There's a variety of legislative acts that occurred from the 1960s through the 1970s, 1980, 1994. That's not even on here. There was a lot of push by the government to say, you need to get creative with your financing. There was concerns after the savings and loan industry took a tumble, if you will, about how we go about these innovative new practices. But in general, it was we need to get out there and get people into homes. And it was even pushed even further after 9/11, saying people need some sense of stability, some sense of ownership, and you need to get out there and get these people into homes. And to do that, we're going to offer these new types of products. So this advantages of subprime lending for borrowers was that they could actually achieve the American dream of owning a home. A lot of borrowers were able to now enter into mortgage contracts where they didn't have to have very much money to put down. They didn't have to show a lot of documentation as to how much money they made. There was just so many advantages to people that wanted to own a home. We also saw a turn in how homes were treated. With subprime lending and just lending in general through the mortgage system, people started to see property, personal property, as investments. You know, this is contrary to our parents or your parents who originally bought homes, and this was their place they were going to live. They didn't really buy it to make money on it and turn it over. But borrowers started to sense that this was a valid or realistic approach to buying homes. They could buy homes And a lot of people ended up buying multiple homes. For lenders, subprime lending also facilitated new opportunities. And there's some of those listed here. The key here is that lenders were able to make loans and pass on that risk to other parties. In the past, if you wanted to get a home loan, you'd go to your local banker, and the banker would give you a loan. They'd known you all your life. They know where you work. You get the loan, and the local banker holds on to that loan. Okay. Well, all of a sudden, new doors opened up where these local lenders were able to pass the risk on, pass that loan on to somebody else. And eventually, that loan would end up in what's called a mortgage-backed security. So some of you that have taken securities law and other corporate law are going to understand some of this. But basically, it left local lenders with the ability to pass on the risk. And it kind of went down the food chain there. Here's an idea of how fast this occurred, too. In the early 90s, less than 1% of mortgages were subprime mortgages. Within 10 years, it had blossomed to about 9%. It increased substantially, like I said, after 9/11. Part of that was there was a lot of new independent mortgage brokers in there who would also help facilitate these loans. We had mortgage investors who stepped up and said, we want to buy some of these loans through what we call mortgage-backed securities. So it grew exponentially within a relatively short period of time. This just gives you kind of an idea of the process by which a loan moves through the system. I won't spend a lot of time on this slide here, but this is something we had talked about in the article, how that from the initial borrower all the way through, that loan is handled by a number of different parties and in a number of different ways. So that by the time your mortgage, person A's mortgage, gets to your retirement account with the state, it's gone through a lot of hands. Okay. The thing is that as it goes through all those hands, it has a lot of opportunities to be tweaked and to be misunderstood. So that when you pool person A, B, and C's mortgage together, you don't really know what the risk is from person A or person B, person C. It's just sold as a quality investment on down the line. Whenever there's any type of innovation in the financial system, there's potential for harm. Okay. The crisis that occurred in 2008, 2009, after the bust of the housing market, you could look back and say this was predictable. Okay. There's a lot of things that go along with a boom-bust cycle, especially when you've got some type of innovative practice or policy or product. So a lot of this was predictable. And again, I go into that in the article as well. Part of the problem is that we were being able to pass on risk, not we, but the finance industry was able to pass on the risk continually through this system. And it was being encouraged. The government agencies were being encouraged to buy these and process these types of products. There wasn't a lot of consumer protection out there. We had pretty sophisticated products and a lot of new people to the mortgage system that didn't quite understand these products. So when you can make money and bear no risk, the potential for harm increases. So the types of fraud that you might be interested in that occurred in the mortgage system are listed here. But you can see everyone from borrowers to all the way up to the rating agencies were involved in misrepresentations. Now, at the height of the mortgage crisis, most of the fraud that was occurring above the borrower level. Okay. So that even though that people in the community that wanted to buy a home were committing fraud by saying they earned more than they did, it was the system itself that was seeing most of the fraud. Thankfully, today, we're seeing a turnaround in that, and most of the fraud that's being uncovered is occurring at the borrower level. And that's okay. I mean, we have systems in check. Crime's going to occur no matter what environment you're in. But when it becomes systematic, that's when we have a big issue. So as a criminologist, one of my goals is to try to explain this type of behavior. How does an organization become criminogenic? How do people that are involved in a system think it's okay to commit crime? There's a number of different theories that we can use to explain this type of behavior. I won't go into those in detail here, but I want to focus on this opportunity perspective. And when we talk about crime and criminality, sometimes we use this theory called routine activities, and some of you might be aware of that explanation. And what that suggests is that when certain factors come together in time and space, the crime event itself is more likely to occur. And that requires three things: motivated offenders, suitable targets, and a lack of capable guardianship. So for example, in the housing finance industry, we had a lot of commission-based brokerages. However many mortgages you can sell, how many loans you can write up, you're going to get paid based on that. So there's an incentive there to make a lot of money. We'd never seen profits like this before in the housing markets. You know, people were able to make these loans, make a lot of money, pass on the risk. Okay. But there also became this tone within organizations that says, do whatever you need to make us money. We're going to make money, you're going to make money, we're all going to be happy at the end of the day. And in doing so, they've pretty much condoned the do whatever it takes mentality. So definitely motivated offenders existed and came to the mortgage industry to make money. And they had plenty of targets there. The subprime mortgage itself was a prime target for taking advantage of people. Some of the people I interviewed for this project years ago said, you know, people don't read. They don't read contracts. I mean, we just signed something about being video recorded. I didn't read it. I just trusted that, you know, it was okay to sign it. I had one lender said, I had one guy in all my years of lending that came in and actually read all of the mortgage paperwork. He goes, I just think he was trying to impress his girlfriend. But, you know, nobody reads that stuff. You trust. Okay? And in doing so, people were able to violate that trust and take advantage of you with sophisticated products that sometimes they didn't even understand. Lack of guardianship. Well, if you didn't read it, you don't know what your rights are. You don't know what the rules are. A lot of the guardians and regulators were not understanding of these products either. A lot of poor due diligence, which I'm sure is something that you talk about in school. But there was also this enabling legislation that said, get people into homes, whatever it takes. Okay. So when you put those three together in an environment or in time and space, crime is more likely to occur. And really that can be summarized to say that subprime mortgaging created an opportunity for deviance. That no matter who came into the system at that time, they were more likely to misrepresent, to commit fraud just based on a convergence in time and space of these different conditions. So I like to think of mortgage fraud as occurring under this kind of opportunity perspective. And there's some of the points that can be made to suggest that this is a good explanation. So what that means is that how do we control it? You know, if we understand that there's an opportunity out there, can we just use compliance training? Can we just use ethics training? Can we just rely on people's moral standards to not be deviant? And I would argue no, and my co-authors and I would argue no. So just thinking about ethics in general, there's a lot of reasons why people violate the law or commit ethical breaches. You've heard some of these excuses before. We all make mistakes. There's too many pressures to perform. Okay. The boss wants me to make all this money for the company. What do you expect me to do? So there's a lot of rationalizations there, a lot of neutralizations that can be made. People tend to explain their behavior away once they've been caught. But the big one we see in mortgage fraud was everybody's doing it. And you'll see this in any type of corporate crime situation. This pressure to perform is pretty intense. I found this one quote, and I thought it was very interesting that if you're given time to make a decision, you're more likely to make a good choice than if you're pressured to perform. And you can imagine that when the mortgage industry really stepped up there, it was just so out of control. People were moving so fast, making so much money, that they didn't even stop to think that what they were doing was wrong, or what kind of impact that could have, not only on local markets, but the global economy. All they kept seeing was the money going into the bank. Some of you will be going into corporate law. Some of you are interested in kind of the corporate environment. There's this concept called tone at the top, and I'm sure some of you have heard that before. But basically what it's saying is that it's the responsibility of the corporation itself to set the tone within its organization to get people to comply. Don't accept deviance. Okay. And it starts at the top. Your managers have to set the example for the base employees. And so this is something that you would become very familiar with if you go into corporate law, about how this process works and what the expectations are. You can see here, though, that there's no spot for opportunities. There's no talk about what are the processes within an organization that might create criminal events. So we have to turn to other issues like compliance issues. And you can have a variety of internal controls, external controls. And some of those are listed here. Corporations are expected to do due diligence. They're expected to have compliance and ethics programming. Okay. But we also put laws in place that demand certain things from our companies. And I think one of the other speakers today is going to talk more about this type of issue. But I just wanted to briefly give you an example of some of the things that are out there that help to inform corporations about what their responsibilities are. And surprisingly, you can find some of this in the U.S. sentencing guidelines. What these guidelines do is establish, what it says here, an effective compliance program. That you are expected, if you're going to have any kind of defense to criminal activity that's occurring within your organization, you've got to demonstrate that these things are being done. Okay. You have to have standards. You have to have methods in place to review what people are doing. Okay. You have to enforce these standards. Okay. Similarly, the SEC has regulations that also suggest that you have to have proper policies, procedures, communication, training, etc. So what these regulations do in combination is say, you have to build a culture of compliance. You have to nurture it, you have to monitor it, and you have to discipline wrongdoing when it occurs. So it's encouraging corporate socialization to be compliant rather than deviant. The trouble is, they're very general guidelines. And part of the argument here is that if you want to control an opportunity for deviance within an organization, you have to understand how and why that deviance occurs. So going back to that opportunity perspective. So even though you have credibility compliance, and again, somebody else is going to be talking about this, about how you go about this, hiring the right people, managing them, training them, empowering your compliance staff. That all goes back to that tone at the top as well. But again, very general. You have to get to really specific legislation, though, to deal with what's going on within an industry. If you find that there's insider trading within the food industry, you have to understand how they can get away with it. You have to understand the process by which prices are set. Okay. Same thing in mortgage fraud. You have to understand how people were able to get away with it. And I think not that I'm real big on legislation like this, but I think the Dodd-Frank Act, at least somebody understood some of the processes that help facilitate this type of crime. Okay. So what they did is basically reformatted the mortgage process. So if you go in to buy a home today, you're going to have to show some proof that you have a job. You're going to have to show some proof that you have money in the bank and it just didn't come from mom and dad last month. Okay. There's a lot of more systems in place for checks and balances that we did not have during that whole subprime explosion. People need to state their income, but they also have to prove it. For example, throughout my search of the literature and talking to people, waitresses were coming in and saying they made it $80,000 a year. Okay. Well, back in the day, they didn't have to prove that. They could just state that that was their income. Now, any logical person knows that somebody working down at the local country kitchen is probably not making $80,000 a year. But it didn't matter because nobody required the proof. At least now they've got it back on track to say you have to substantiate that kind of income. You have to bear some of the risk at the local level and all those levels throughout the process. You can't just pass these mortgages on anymore without being held accountable for that. So a lot of changes were made at different parts of the system to try to get down to the opportunities for which fraud was taking place. So again, I think Dodd-Frank understood some of that. They understood, for example, the fraud that was happening at the appraisal level, at the rating level, at the securities level, and they were able to incorporate that. Now, it'll still be some time to see whether this legislation is effective, and if you understand opportunities and understand criminal thinking, people are going to create opportunities for themselves, especially if there's any kind of innovative product out there. Knowledge is power. Okay? If I understand this process better than you, I can take advantage of you. So you're going to always have motivated offenders out there. But the key to not making it endemic or systemic is to control the actual opportunities. And I think this legislation goes a long way in doing that. To say, time out here, we need some more accountability, we need more transparency in the process. So just to summarize here, if you really want to control white-collar crime, our argument is that you need to take an environmental approach. You need to do industry-specific analyses. You need to actually harden the targets. So for example, we can't control the number of motivated offenders out there. But we can control the suitability of a target, just like we do in other aspects of crime prevention. We can also improve the guardianship. Okay. So if we can disrupt that convergence in space and time of targets, offenders, and guardianship, we can limit the opportunities for fraud. We can limit the opportunities for white-collar crime. But again, you have to understand exactly what's going on within that system and how decisions are made and how people are able to take advantage of innovation. So a systems approach, very important. I think you could use this type of explanation to discuss other types of crime, environmental crime, other types of crime in different industries. I think that's about it. Thank you. Thanks.
Thank you.
Get that out of there for you. Okay.
Thank you, Dr. Kohler, for a very interesting presentation, and I hope that we'll have an opportunity to delve into some of the issues raised in your presentation, specifically this culture of compliance and how this culture of compliance can be established instead of a culture of corruption and a culture of impunity that we often see with large corporations, an effort to avoid and evade regulations rather than comply with them, to look the other way and turn a blind eye, or just give lip service, to the regulations that, the legal obligations that are established pursuant to these regulations. Our next presentation is actually a tag team presentation by two speakers. First, let me introduce Dr. Gerald Cliff. Dr. Cliff is a career police officer, administrator, most recently retired from the position of Chief of Police of Saginaw, Michigan Police Department, where he served from 2005 to 2012. He retired from the Detroit Police Department in 2005 at the rank of commander. Among the positions he held during his tenure, Dr. Cliff served as the commanding officer of the Violent Crimes Section, made up the Violent Crimes Task Force, the Repeat Offenders Unit, and the Crime Analysis Crime Mapping Unit. He also served as commanding officer of the Special Investigations Section, which is made up of the Armed Robbery Special Victims Unit, Child Abuse, Domestic Violence, Commercial Auto, Theft, Cybercrime. I mean, I think he did it all in that capacity. Dr. Cliff also served as the commanding officer of Training and Compliance, the Training and Compliance Section of the Civil Rights Integrity Bureau of the Detroit Police Department, a unit established specifically to deal with 2 U.S. Department of Justice consent decrees. While serving with the Detroit Police Department, Dr. Cliff worked to obtain 2 master's degrees, one in Criminal Justice Administration from the University of Detroit Mercy, the other in Industrial and Labor Relations from Wayne State University. In 2003, he graduated with a PhD from Wayne State University with a major in Public Administration and minors in Policy Development Analysis and Urban Politics. So he brings both a practical, hands-on, experiential perspective to the issue, the subject of white-collar crime, as well as a very in-depth academic perspective. His co-speaker is Christian Desolé, okay, excuse me, I apologize, who is a lawyer. He's a research attorney for the National White Collar Crime Center. He performs legal research relating to the fields of white-collar, cyber, and financial crime, and helps create training for state and local law enforcement. He is a member of the West Virginia State Bar, a graduate of Georgetown Law Center, where he specialized in internet, computer, intellectual property, and white-collar crime issues. Before attending Georgetown Law Center, he pursued his academic studies at Mississippi State University, where he began as an electrical engineering major and graduated with a degree in sociology, a minor in computer science, and a certification in criminal justice and corrections. He was awarded the Alpha Kappa Delta's Sociology Undergraduate of the Year Award for the MSU chapter in 1997. Between completing law school and accepting employment at the National White Collar Crime Center, he worked in a patent-oriented legal practice in Northern Virginia, primarily doing legal work on software and web-based utility patent applications. The title of their presentation is White Collar Crime, What It Is and Where It's Going. Basically, their paper delves into the definition of white collar crime. When we use that term, white collar crime, what does it mean? What kinds of crimes does it encompass, incorporate, and why? So with that, please welcome our two speakers. Thank you.
Slideshow from beginning. Okay, I've got the first few minutes here, and first off, I want to thank you. Oh yeah, how do I? I want to thank everybody for inviting us. It's truly an honor to be, part of this, and it's also confusing with all the unfamiliar technology, but okay, it's up there. Good. I thought that it would be appropriate, since we're discussing white-collar crime, to kind of give you an introduction the way I got the introduction. as you heard, this wasn't one of my primary areas of expertise before I came to the National White Collar Crime Center. I kind of had to educate myself, and literally every book that I've read about white collar crime has started off with, all right, I'm going to have to use the keyboard here, has started off with the definitional, I guess you would call discussion, as opposed to a debate. What is white collar crime? And what is the National White Collar Crime Center? So I'll back up. The center, in case nobody's heard of it, and a lot of people haven't, it's a nonprofit organization. We're funded by grants from the Department of Justice. We're funded to train state and local law enforcement in the skills necessary to investigate white collar crimes. The definitional issue that I was just speaking about is one of the first things that we learn when we're getting into the field of white collar crime is what is it? What makes up white collar crime? What categories fall under white collar crime? And it's really tough to define. It can mean a lot of different things to a lot of different people, depending on your perspective, depending on your time in history that you're talking about it. It's a term that's been around for a lot of years, and it depends a lot on what your focus is. Are you focusing on the orientation or the nature, the characteristics of the crime itself, or on the characteristics of the offender? The first time it was the term was used that pretty much everybody agrees on was back in 1939 by a sociologist by the name of Edwin Sutherland. His definition was white collar crime is crimes committed by a person of respectability and high social status in the course of his occupation. Back in 1939, they didn't have mass communication capabilities like we have today. There was no internet, there were no computers. To commit a white collar crime, a Ponzi scheme, for example, you had to sell something to someone on a kind of a face-to-face basis and then hope that by word of mouth the scheme kind of spread and your profits would mount from there. And normally, I think what they were referring to were the banking executives, the bookkeepers that were in positions where they had access to finances and they had the ability to conceal what they were doing to some extent. So they capitalized on their position and they committed a crime of opportunity, diverting funds away from the organization and into their own uses. Sutherland's view, so it really doesn't fit if you think about it. A business owner commits white collar crime when he's lying about business related taxes, but not when he's talking about his own personal taxes. There's the idea of the professional status. I mean, how high a status is high enough to make a crime a white collar crime? The CEO of Walmart, a Walmart cashier, they can both embezzle funds. An organization can commit, or theoretically can commit, I don't know if legally an organization can be held responsible for a crime. You could probably ask the CEO of Toyota yesterday whether or not that were possible, but a lot of different ways to look at the whole concept and the whole term of white collar crime. I think the best definition that I've seen to date is Herman Edelhertz put forth the definition in 1970. It's an illegal act or series of illegal acts committed by non-physical means by concealment or guile to obtain money or property, to avoid the payment or loss of money or property, or to obtain business or personal advantage. If you think about it, that kind of covers the whole gamut. At least it does a lot better job than Sutherland's concept or his definition. Committed by non-physical means, that's pretty much, in line with Sutherland's theory. Concealment or guile, that fits. Obtain money or property. These things cover a much broader range. He talked about 4 different types, basically. Personal crimes committed by persons operating on an individual or ad hoc basis for personal gains. That could be the identity thief, that waitress that that we were talking about a minute ago that happens to Maybe she made her $80,000 a year by running your credit card through a card reader, transferring that information to a computer, stealing your credit card information, and then using that to purchase goods and even convert it to money. The abuse of trust is another type that Edelhertz talked about, committed in the course of perpetrator's occupation. Again, that goes back to the embezzlement concept. Somebody that's in a position where people trust them to handle the money. They expect that they're going to handle it in an ethical manner and an efficient manner. Then all of a sudden, the money's gone. Now, that could be the CEO of General Motors. It could also be the treasurer of the local PTA. Which one's committing the white-collar crime? Is the treasurer of the PTA really a white-collar criminal, or is it just somebody that saw an opportunity and decided to capitalize on it? Business crimes. Crimes incidental to or in the furtherance of business operations, but not central to the overall purpose of the business. That's the position of the positional aspect. Somebody that's in a position where they have the opportunity to take advantage of the circumstances to their own benefit, or just plain old con games. And we see a lot of that out there. I don't know how many people have gotten letters from Nigeria telling you that you've won, or that asking you for your help in gathering large sums of money from a nondescript bank account and so on and so forth. People fall for that. That's also considered white-collar crime. Edelhertz views, like I say, it's fairly easy to operationalize. It makes it a go-to definition for people who want an easy measure of white-collar crime. And the FBI actually adheres pretty closely to the 1970 definition when they talk about white-collar crime. But what was interesting to me is, and I'd never looked at it as a person involved in violent crime, we kind of live and die by the Uniform Crime Reports. You go to the Uniform Crime Reports, there's no section on white-collar crime. The reason there isn't is because you can't measure what you can't define. If you can't agree what belongs in the category, you really can't come up with an accurate measure, a definition, or realization, I guess you'd say, of how much damage white-collar crime is doing to society, how many people it's hurting, the financial impact of white-collar crime, and so forth. The FBI's definition, those illegal acts that are characterized by deceit, concealment, or violation of trust, not dependent on application of threat or physical force or violence, committed to obtain money, property, or services, or to avoid payment or loss of money or services, or to secure personal or business advantage. Again, it's a fairly all-encompassing definition, and yet they still don't have a section in their own Uniform Crime Reports that say how many white-collar crimes are occurring, how much it's costing us, how big of a threat it poses to our society in general. And that's kind of the issue. In 1996, our organization, NW3C, came up with the idea, we'll convene a bunch of really bright people, some really top talent, big-name academics in the field of white-collar crime, and we'll see what they come up with. They came up with illegal or unethical acts that violate fiduciary responsibility or public trust committed by an individual or organization, usually during the course of legitimate occupational activity by persons of high or respectable social status for personal or organizational gain. And again, you can see there's a whole lot of wiggle room in there. There's a lot of things that could fit, a lot of things that might not fit. Trying to take a particular act of illegality and fit it into the category of white-collar crime is going to be, a discussion or a debate in and of itself. So why define it at all? You can't measure what doesn't have a generally accepted definition. Policy issues and legislative issues. How do you go to legislators in Washington and say this is a huge problem? Example, mortgage fraud. We need to enact laws. We need to do something about this. We can see the problem arising on the horizon, and we need to do something about it. If you don't have measures, you can't do that because there's always going to be on one side of the aisle saying, oh, that's not a problem, the other side of the aisle saying, oh, it's a great big problem, the world's coming to an end. there's no way to assess the effectiveness of measures to address white-collar crime if you can't measure it. Think in terms of the utilization of the Uniform Crime Reports, yearly reports of defined offenses that are used to assess the effectiveness of all of the above. There's nothing comparable for white-collar crime. When I was chief of police, we lived and died by the Uniform Crime Reports. Our city, our local newspaper would call me up every October and say, well, how are we doing this year? And I could tell them, because what they were focusing on was violent crime. Fortunately for me, they weren't asking about anything that would have fallen under the subject heading of white-collar crime. And with that, part two, and I'm going to turn it over to my able assistant, my attorney, Christian.
Hi. All right, so my job is to get through the rest of the slides without turning into an auctioneer in the middle. So here's hoping that works. So we've covered already that white-collar crime has different meanings to different people. There are different definitions depending on what you need to find out about white-collar crime, what you're looking to understand, what your questions are. And that determines how you define it, what you're looking for. So that makes it hard to measure. There we go. All right. That doesn't mean that we can't measure it some, and that we can't say some things about it, no matter how you're defining it. Before we get into that, though, we need to have an idea of a baseline. So if I say you got an incident rate of 5%, is that high, is that low? We need to have some idea. We look to the UCR and the NCVS. The UCR, the Uniform Crime Report, is based on reports to police. The National Crime Victimization Survey, NCVS. The BJS reaches out to homes and families and asks them about their experience with crime in the previous year. So they get different kinds of answers. You'll notice, though, that the trend is going down. There's a general negative trend. This trend isn't new. It's been going on since the 70s. Hallelujah, it's a great thing. The world is generally safer than it was. That's a good thing. You notice that it stops in 2010? There's a reason for that. I'll tell you about 2 slides. But there's been a minor uptick near the end. Don't worry about it. These things just happen. All right, you notice NCVS is higher than the UCR. That's because a lot of things aren't reported to the police. All right, so for white-collar crime, the NW3C said, all right, there aren't good statistics on white-collar crime that we can find. We want to generate them if we can't find them. So we're going to try to emulate the NCVS. As it turns out, that was horribly expensive. We couldn't do that. So we pared back our expectations a lot and tried to do a much more focused thing. What we found was that 24% of households have been victimized by white-collar crime in the past year. That's twice as high as property crime under NCVS. It's also 11 times as high as violent crime for individuals, but they're not really as comparable, so it's not as important. All right. Hopefully, though, this has set up something for you. You're asking, all right, but what is white-collar crime for you? Good question. We break it down. I'm not going to read from the slide, but here you go. As you notice, these are all things that target individuals, things that target families, target consumers. This is what we asked. This is what we didn't ask. As you notice, there are some huge gaping holes here, things that are giant endemic problems for society, but we couldn't reach out to families and ask them, hey, have you embezzled this year? Have you embezzled from you? These aren't questions that make sense for the individual as much as for organizations. Rates are probably higher than that. 24% is pretty scary. That's almost 1 in 4, and they're probably higher. Now, a lot of these factors affect everything, right? No matter violent crime, street crime, white-collar crime, you're going to have undetected behavior, things we didn't ask about, and things that people are too embarrassed to discuss. But white-collar crime in particular, pay attention to numbers 2 and 3 there. Things we were unaware that you're a victim, right? Price fixing. Were you affected by price fixing this year? I don't know. Maybe. Probably. Sure. Right? And criminal behavior that's perceived as a civil matter. As a civil matter. Say you're ripped off at the auto place, right? Are you work that out with them? Are you going to file a lawsuit? Is that a fraud? You could go any of those 3 routes. As a society, there are a lot of things we just don't see as white-collar crime, even though it technically meets the definition. Arguably, it's more like 100%, right? The recent problems, we're talking about the mortgage fraud issues. The ripple effect from all these crimes affected all of us. So you could say we've had 100% victimization. You could say more than 100%, right? Because these are going to affect future generations. They're going to affect more people than there are Americans. And the question is, what good is that stat, right? Just as you choose a definition based on what you're looking for, you choose your metrics based on what you need to find and what value these would have to you. So 100% victimization is good for raising awareness, but it's not so good for things like resource allocation, right? So another thing before we move off, comparing white-collar crime rates to street crime rates, is that the reporting rate for white-collar crime is really, really low. Right? So we're talking about 12% compared to 37% of property crimes. Now, why is that? I don't know. We weren't able to delve into that. Anecdotally, hey, I've had credit card fraud happen against me before. I think a lot of us have. Right? You see a charge on your account. You don't know where it came from. What do? Do you call the police? Maybe. I called my bank. So does most everybody else. And then you're done, right? I mean, you could call the police, but most people don't. So because there are alternate routes for resolution, there are other ways to be made whole. White-collar crime rates tend to be, reporting rates tend to be low. All the same, we wonder if white-collar crime actually is that common. Well, why, right? Why not? The things that are required to commit white-collar crime are more common in our society now than ever before. Right? We have the ability, right? Literacy, computer use, education. These are all up. They've been going up every year since we started measuring these things. They'll continue to go up. More and more of us can commit white-collar crime. Also, more of our wealth is embodied in information or information products. When the Business Software Alliance says that it lost billions of dollars in software sales to piracy, they're not talking about a physical thing, right? There wasn't a holdup. There weren't, people didn't have guns go in there and rob copies of boxes of Windows. No, they're talking about the abstract concept of information, the hypothetical lost sales, right? There was a time when if you weren't holding something in your hand, you didn't have money. We're way past that. Money more and more is informational, it's transactional. And the only way to really get to those is white-collar crime. Finally, we have opportunity. As our job market changes, we have more people who have access and who have opportunities to get at the money going through an organization. If you're working in a field, if you're in a steel mill, there aren't as many white-collar crimes you could just logistically commit. Further, computers and the internet have had a huge impact, especially the internet. Right? 87% of all American adults use the internet. That's huge. We used to talk about a digital divide. We used to say, hey, when are our poor, our ethnic, our minority, when are they going to get online the way that the rich white kids do? And that's not an issue anymore. It really isn't. The question nowadays isn't, are they online? It's how are they online? So we find that among the youth, among the ethnic, among the more up-and-comers in technology, they're more on smartphones than on computers. But they're all online. Especially social lives, right? Most people who are online are also online socially, especially as you get down into the younger age groups. Right? 18 to 29, 90% of people who are online are also on social media. Now, when people are online socially, all the things that happen in their socializations are also there. All the victimizations that happen in social contexts, right? Those scams can't happen unless you talk, unless you hang out, right? The bullying can't happen unless you're there. All the things that happen offline where we hang out, at least happen on the street corner, can now happen online, just in different venues. So that's why when we say cybercrime, I like to look at it more as an adjective than a noun. It's not a thing, right? Cybercrime isn't a thing like mortgage fraud or embezzlement. It's a vector. It's a way things happen. It's a way that scams happen. It's a way that embezzlement happens, right? And when you look at contact opportunity theories, one slightly scary thing about it is that you have access to so many more people in your life through the internet medium, right? People you haven't talked to in years still touch you. People who maybe in your neighborhood, people from 20 years ago, they all have contact. For that matter, for a business, you had a locked filing cabinet, right? Maybe you'd have to look at the neighborhood that building's in. You'd have to see who had access to that room. But you could narrow that down pretty quick and easy. In the online environment, you can't do that, right? Somebody from Russia can dial you up, and you're just as close to them as something down the block. You also have low barriers to entry. Used to be an archetype of the computer nerd, working in his basement and coming up with great hacking software. That's great for 1986. As it turns out, nowadays there's an app for that, okay? You can download it. Somebody has already done the hard part for you. They've thought it through. You can get your Trojans. You can get your viruses. You can get scamming software. You don't have to do the hard work. And when you're on there, the victimizations are in the offline environment, right? You'd have to go up. If you wanted to scam somebody, you'd have to talk to Jerry. You'd have to go over to talk to that guy or that guy. And you'd have a one-on-one communication. You'd try to get something to happen. Online, you could automate this. You can do 1,000 people in a day. You can do 1,000 people with a button click. You can harvest a botnet. You can get a huge group of computers doing the work for you. Now, along with that comes distributed victimization. Cops might investigate a $20,000 loss. They're unlikely to investigate $1,020 losses, especially if only one of them happened in their jurisdiction and got reported. So, pseudonymity comes with that. The disinclination to, sorry. All right, I'll take a drink. Give me a second. With pseudonymity, you have the idea that maybe consequences don't come back to you. It just frees people up. Finally, you have the relative lack of enforcement. The truth is, and I hate to say it, cybercrimes are just not prosecuted at the same level that regular street crimes are, and nor are they researched. Now the question is, how big is cybercrime? Big. We're looking at about twice as big as a global black market in heroin. That's pretty big, as I hear. So, and that's not even looking at the amount of the black market for heroin that was on the internet, right? Anybody who here has been following Silk Road? We're only looking here at direct losses to consumers. We're not looking at all the crime, all the black market dealing, all of that happens on the internet itself. And as we're saying, law enforcement responses been fairly weak. They're trying, but they're playing catch up. They don't have the resources, they don't have the training. So that's about it for us, though. We do cover a lot more in the paper about the specific types of white-collar crime, and we just don't have the time to get into it, and I'm sorry. But these are the ways they're happening and the vectors. So thank you very much.
Well, once again, it's a very interesting presentation. I hope that the issue of the definition of white-collar crime is something that we can delve into a little further during the panel moderation. Our next speaker is John Gallo, and John has strong ties to Notre Dame and the Notre Dame Law School community. John is a partner at Sidley Austin and global co-chair of the firm's white-collar practice group. So who better to invite to speak on the subject than John Gallo. He is a trial lawyer. He is a former federal prosecutor in Chicago. His practice includes conducting internal investigations for institutions, representing criminal defendants and grand jury targets, and representing parties in complex civil litigation. Before joining Sidley, he served as an assistant U.S. attorney in the Northern District of Illinois from 1989 to 1996. So we have someone else who has tremendous experience, in the field dealing with these tough criminal law issues. He received the Special Achievement Award from the U.S. Department of Justice in 1993 and 95. He served as a law clerk to the Honorable Anne C. Williams of the U.S. Seventh Circuit Court of Appeals from 1986 to 1988. Since 2002, John has served as an adjunct professor at Notre Dame Law School teaching federal criminal practice. And I know I've talked to many of our students who have taken John's class, and they rave about it and find it to be a very interesting, challenging, and practice-oriented class. John's presentation is titled "The Corporate Criminal Defendant's Illusory Right to Trial, a Practitioner's Proposal for Reform." And so with that, John, welcome, and we look forward to hearing your presentation.
Well, David, am I supposed to get attached to something? Can either speak here or use this, yeah. While we're getting, is that thing on your film? Is that on? I think everybody will be able to hear me. If my reputation precedes me, I think I'm loud enough. I don't think you want me to be any louder. While we're getting set up here, just a quick comment about the title of this tome. The Corporate Criminal Defendant's Illusory Right to a Trial, a Practitioner's Proposal for Reform. So I asked Adrian, I said, what do you want me to talk about at this? Want me to just read my paper to everybody? And she said, no, why don't you tell us about how it came about that you decided to write this paper? And she said a few other things that I could talk about, but that first question is going to occupy the entirety of my presentation. Because if in 1986, when I was in front of the university in Cambridge, when I was in front of the university's endowment building, protesting the college's investment in businesses that did business in South Africa. And if you would have told me then that in 2014, Dr. Blakey, that I would be sitting in front of you asking to increase and make it more difficult to prosecute companies, I think I probably would have committed hara-kiri back at that time. But one of the questions... I definitely gone to the dark side. And we're going to talk about the evolution. It's either an evolution or it's a story of personal decay. So I'll leave that to you guys to decide over the course of this morning. So I'm going to talk in terms of, so why am I here? Why did I write this article? I'm going to really talk about three sort of episodes or periods in my career. The first has to do when I served as an assistant U.S. attorney, and then the second two have to do with cases I've had over the course of my career. So I'll just take them one at a time. So as it was mentioned, I was an assistant U.S. attorney for 7 years. That sounds impressive, but I was 28 years old when I became an assistant U.S. attorney in 1989. And on the day I became an assistant U.S. attorney, I had appeared in court precisely that many times. Zero times. And we received some training when we became assistants. I would characterize it as minimal. The theory, the practice in the office was to be thrown to the sharks, and you learn on the job, and you learn how to ask questions as you practice. And so I was, flying by the seat of my pants, some would say, for most of my 7 years in the office. In particular, what I want to focus you on is what happened to me on days when I was on duty as an assistant U.S. attorney. And when you're on duty, whatever comes in the door that day, you get. And there are two types of cases that you get as an assistant. One are reactive cases where an agent has made an arrest. And the example I'll use, one of my favorite cases was a case of a Greek restaurant owner who, when INS agents came to take some of the illegals who were cooking in back, he stepped in front of the INS agent, and when the INS agent tried to get around him, the INS agent was a little tubby, and he reached around and squeezed his love handles of the INS agent, and the result of that was the agent arrested him for assault. So I got that on my duty day, assault on a federal officer, assault on his love handles. So that's a classic assistant U.S. attorney case. So I'm going to compare that case, which, by the way, then goes into the system, and you appear in front of a judge, a magistrate judge, and there's a review for probable cause. And then you have 30 days to indict the case, and you have to present the case to the grand jury, and there has to be probable cause found. And then you have to actually try the case in front of a Article III judge and persuade a jury by beyond a reasonable doubt that the offense was committed. Remarkably, I won that trial. I think that the picture I showed of the red love handles was what convinced the jury in that case. I highlight that example because that's an example of how the system should work. There's a criminal act that's allegedly committed. The defendant is prosecuted by someone from a different branch of government than the judiciary. The judiciary then governs a proceeding in which there's a determination made independent of the prosecutor as to whether the crime was committed. That's how the system is supposed to work, and it does work. It works very effectively when the case gets into the federal criminal system. I want to compare that to the other kinds of cases that you get on a duty day as a prosecutor, and those are cases, and this is what I'm going to spend most of my time talking about, and those are cases that are logged into you by an agent. These could be agents, most people think, well, the FBI is the agency involved. Well, I learned there's many more acronyms in federal criminal practice than the FBI. There's the DEA, there's the IRS, there's the ATF, there's the DOL, there's this Social Security Administration, there's the FDA, there's the DOD, there's the EPA, there's the INS, there's Customs, there's DCIS, there's the U.S. Fish and Wildlife Service, okay, carrying guns. Now, these agencies have the ability, or had the ability, I think they still have the ability, the way the office works, to come into the U.S. Attorney's office and go without talking to a single assistant U.S. attorney. They go into a room and they talk to an administrative person, and they log a case in and they identify subjects of their investigation. And the agent might just identify one subject, or the agent might identify 25 subjects. But an agent decides who are the subjects who are identified on the piece of paper that's presented to the office. And that case, when it's logged in, when I'm on duty, becomes my case. Now, the way the office worked at the time, and different offices work different ways, but I'll tell you how that office worked at the time, was agents could get subpoenas, grand jury subpoenas, to serve on anyone they'd like by going to my secretary and getting the subpoena, filling it out, and then basically leaving it for my approval sometimes. Sometimes they didn't leave it for my approval, but they were supposed to leave it for my approval. And having the vast criminal experience I had at the time, I chose to let pretty much every subpoena go out. So when a person is served with a grand jury subpoena, even if it's for documents, I had no sense at the time of the significance of that event. And when I'd get calls from lawyers, as I typically did after serving subpoenas on their clients, I would get a call, and the call would be, I received a subpoena for my client, Mr. Smith, served by this DOL agent. And my question, sir, is my client a target or subject of your investigation? Well, I had usually by that point in time some knowledge of what the case was about. But the standard answer that you give in that context is, don't know yet. I can't tell you if your client is a target or subject. It remains to be seen. And I'll come back to that in a minute. But I just made that passing comment. I would make that passing comment 3 or 4 times a day to lawyers who'd call asking questions about their clients. Sometimes agents would come to me on my duty day and they would ask for a search warrant. And there would be time sensitivities for those search warrants. And sometimes the affidavit that was presented to me by the agent was, it was clear there was heavy-duty criminality going on, drug dealing, gun running, whatever. But in the case of fraud-related cases, the evidence is highly or was highly circumstantial. And particularly in the case where whistleblowers, internal company whistleblowers were making the allegations were very complicated, very difficult for me to understand, and had to do with concepts with which I was frankly personally very foreign. So what I would typically do is say, looks good. Let's present it to the magistrate judge. And the magistrate judge, no more educated about these matters than I was, would say the same thing, looks good. And I can tell you that as I was going back through the cobwebs of my mind, thinking about cases like that, I thought of 3 or 4 cases where I authorized the execution of a search warrant in a situation where the entire financial document set of a company, one defense contractor comes to mind, was taken by the Department of Defense and brought back to the Department of Defense, basically preventing the company from operating or functioning at all. And then those documents go to the agent's office and they sit there, you know, in a white-collar case, routinely, not for a week, not for a month, not for a year, but for years, and with really no ability for that company to get those documents back until the investigation is over on a good day. Over the years, while I was an assistant U.S. attorney, there were a number of parallel investigations that I was involved in. By parallel, I mean I was a criminal assistant U.S. attorney. That meant that I was responsible for the criminal cases in the office. Now, there was a whole other side of the office in Chicago that was the civil division of the U.S. Attorney's Office. Civil assistant U.S. attorneys, they had no criminal authority. They didn't preside over grand juries. But there were many cases we had, defense contractor fraud, healthcare fraud cases, and the like, where there were parallel civil and criminal investigations. And FDA, another example. Now, the rules are that as a criminal assistant U.S. attorney presiding over a grand jury, I am not supposed to coordinate my investigation with the civil division at all. It's a no-no. You can't do it. It's against the law to do that. Now, when I was an assistant U.S. attorney, I never had a case, frankly, where the parallel investigation led to a criminal consequence. In those cases, essentially, many of those cases, what happened was the civil division operated completely independent of what I was doing. I would serve subpoenas. Occasionally, it would end up in a result, but there was no, in practice, no active coordination or attempts to coordinate. But the reality was that there was, even in the cases like the example I gave you of the search warrant on the Department of the defense contractor, where the documents went into a space and were never seen again by me. In that case, there was a parallel civil investigation by a civil DOJ lawyer where it did end up with a disposition for that company, and I only learned about it after the fact. Over the years, there were cases that were logged into me in my first couple years in the office, which the week before I left the office, I had to go back to my files and see what I had there, and declined dozens of cases that had accumulated over the years, many of them cases where the statute of limitations had passed or told. So what essentially what happened was some of those cases when I was a first or second or third year assistant U.S. attorney, when I left after 7 years, those cases were declined, and we didn't, as a practice, notify the subjects of the investigation, people whose lawyers I'd talked to 5 years before, that the case had gone away. So I left the office, phase one of my talk, I left the office, declined all my cases, left with whatever laurels I had gained by virtue of prosecuting cases, and went into private practice, where I'm now going to talk to you about phase 2 of my talk, about why I'm here. The first reason I'm here is because of Ken Austin. Ken Austin. Ken Austin is a man from Minnesota. Ken Austin was the chief operating officer of Iroquois Pipeline. Ken Austin was the guy who was responsible for the building of a pipeline, a natural gas pipeline, from Canada down through upstate New York and down into the mid-Atlantic region. 275-mile pipeline. And it went through, unfortunately for Ken, Syracuse, New York, where there was an assistant U.S. attorney whose name, and this is not a joke, his second name was Benedict. And at the time when I heard his name, this is before Pope Benedict, there's another Benedict that I got to thinking about when I heard this name later. So what happened was, this 275-mile pipeline, Ken Austin, and I came to Sidley, and Ken Austin had already been indicted. My partner, Tom Green, in Washington, D.C., is a very prominent criminal defense lawyer, and he, at the time, I thought very generously, until I later realized what had happened, gave me this case and said, John, I'd like you to work on this case in Syracuse, New York, and I had nothing else to do, so I took the case. What happened was I came to learn that Ken had been indicted for violations of the Clean Water Act. And way too complicated to explain this in the time I have left, but the bottom line is, one of the allegations was that Ken was responsible for a violation of the Clean Water Act because there had been a violation of the Army Corps Engineer permit, which itself said, among other things, that there shall not be a rock bigger than 18 inches leaning up against the pipe, a 275-mile pipe. This is a true story. Ken had been indicted because, as the COO, he was a responsible corporate officer for a violation of the Clean Water Act. And so, long story short, what happened was that the company, Iroquois Pipeline, which was represented by another firm, was also indicted. They were indicted because of the standard of vicarious liability for companies, which is that a company can be indicted, read the paper, it'll talk about this at length, if an employee engages in a criminal act within the scope of their authority and if the agents intend in part to benefit the company. So the allegation was that some employee of the company had known that there was an 18-inch rock against this 275-mile pipe. And we're going to call a witness to testify to that. And that when that rock was put up against the pipe, that it was done for the benefit of the company because they were building this pipeline. So, and by the way, there's another piece of this you need to understand in corporate criminal context, and that is the concept of collective knowledge. So that if two different employees have two bits of knowledge, you can, according to legal doctrine, take those separate bits of knowledge and make it part of one corporate brain. So in this case, one employee knew that there was an 18-inch rock, and Ken, my client, knew that there weren't supposed to be any 18-inch rocks against the pipe. Well, according to the law of collective knowledge, that was enough. There was other circumstantial evidence, but I'm just using one example here, to put together enough knowledge to cause Iroquois Pipeline to be held liable because collectively there was knowledge in the company. Two different people make one corporate brain. So, frankly, I was pleased to be representing a defendant who I was so fond of and I thought was so innocent of any wrongdoing. But I was stunned that this prosecution had ever been brought. And I came to learn that a single, and I knew it from Chicago, but it was even more, it came more starkly to me at the time, that a single assistant U.S. attorney in Syracuse, New York, can make a decision to bring a case and bring a charge like that, and ultimately, to prosecute that case. Now, what ultimately happened, the good news is we went to the Department of Justice, the environmental section in Washington, D.C., and ultimately the case was dismissed. So for Ken, justice was done. But my comment, sort of the next comment, is for many, many, many corporate directors, corporate officers, senior managers, people who receive subpoenas from 28-year-old assistant U.S. attorneys randomly passed out and then are told through their lawyers that there's been no determination yet of whether their targets are subject of an investigation. There's a sort of a undertone of what I'd characterize as the danger of government overreaching. So, sort of segueing to the third part of my talk, I need to talk for a minute about how, in practice, these cases are actually done. And so, in practice, what happens is that a company will become a target of a corporate criminal investigation, and large companies, Pfizer, General Electric, GSK, you name it, Aon, companies with literally hundreds of thousands of employees have a single employee in a single place who on a single day commits a criminal act. And that employee could and should be personally prosecuted for that act. That employee committed that act while wearing the corporate shirt, having corporate authority. That employee committed that act in part for the benefit of the company. So, classic example is a bribe-paying employee who pays a commercial bribe to do something so he makes a bigger commission, but it also helps the company. That bribe may have been against the company's corporate policies. No one in senior management may have known about it, did know about it. If they did know about it, the employee would have been fired. But all it takes is for one of those acts by one of those employees on one of those days for a company to be threatened with prosecution by the executive branch. In a situation like that, well, you ask yourself, so okay, well, why doesn't the company fight? Why doesn't GE or Pfizer or Aon or that company fight in that situation? Well, there's a series of reasons they don't fight. Number one is every company has one bad apple that's going to do that act at some point in time. It's the nature of the human condition. Number two is the standard for entity liability is low. I've just described it. Number three is, and these are the critical ones, if you lose and you become a felon as a company, that is, for many companies, a death sentence. It's a death sentence because you're excluded from doing business with the federal government in any capacity. You're debarred, you're excluded. You can't, if you're a provider, you can't get Medicare. If you're a defense contractor, you can't do business with the government. Now, even if you have a case where you don't think your employee did anything wrong at all, so I use the example of a commercial bribe. Let's take a case where you do an investigation and you discern nobody did anything wrong. In fact, you think the employee did everything right. Why don't you fight? Why don't you take the government on? Well, because even any trial lawyer will tell you this. Any case that's brought by the United States government, first of all, they win 90+% of every case that's brought. There's a presumption of innocence, but in practice, when you have the flag next to you, it's not a presumption of innocence. Jurors presume, as a practical matter, the government doesn't bring cases against people that are innocent. How much? Okay. And I think I'll make it. Okay, so the bottom line is people don't, so you can't, so it's presumption of guilt, but more importantly, any case you bring in front of any juror, you have at least a 10% chance of losing that case. The best case, you don't know what juries are going to do. And if you do just a risk analysis, you're not going to find, a company can't do 10% chance of going out of business. You can't try that case. So, trying to keep within my 5 minutes for Angela here. The last story I'll tell you is that in November of a year, I got asked by a friend to represent the directors of a company, a large company, a provider. And they'd all been subpoenaed to the grand jury in this location. And no one else had yet been subpoenaed. These were the first subpoenas that had been issued by the prosecutor. I called the prosecutor. He didn't give me any information about it. He said, look, John, if you bring all these guys to my location, I'll tell you what, we'll agree to do it outside the grand jury with the court reporter. I said, fine. I brought these corporate directors to be what was essentially deposed by this prosecutor, and the questions included questions about the corporate director's personal wealth, how much money they had, what was their net worth, questions about whether or not the directors understood that if the company was prosecuted and the company lost, there'd be class actions and they'd be personally liable for those class actions and exposed, their personal wealth exposed. Whether they had decided to conduct an investigation, and when questions were asked about whether that had happened and privilege was asserted, the prosecutor said, well, if you're going to interfere with this examination, then I'm just going to take it in the grand jury, John, where you can't be present, and I'll ask the same questions. Now, for anybody who's practiced law and has any understanding of criminal law, that was abusive. It was inappropriate. It is rare, but it happened. That is a case where the sword of criminal liability hung over that company until it ultimately decided it could not fight. It could not expose its senior management and directors to individual liability in a case where the company thought they didn't do anything wrong. So the net outcome of that was a civil resolution for hundreds of millions of dollars because the company did not think it was in a position to fight. So my last story, in that case, I remember being present at a board meeting when our local counsel, we were at the board meeting making a presentation to the board about this case, about what had happened, and our local counsel got a call from the U.S. Attorney's Office in the case. There had not been a determination to not prosecute criminally. And he left the office, and he left the room and came back in and reported back to the board that the U.S. Attorney's Office made the decision to not prosecute any individuals for anything that they had done in the case. And so after that presentation, I happened to go into the bathroom after the long presentation, and I ran into one of the directors who was weeping in that stall with relief after finding out, after years, he was not going to be prosecuted. So, Angela, that moment in time is what I thought about when I was asked to write this article last summer. Now, none of this drama appears in the article, so if you're expecting to see any of that, it's not in there. So, but that, the ability of the government to leverage the criminal process to essentially, to put it bluntly, shake down civil dispositions for hundreds of millions of dollars is problematic. And so my paper makes some modest proposals for limiting the government's ability to do that. And I stand here today proudly as a subscriber to the Wall Street Journal. So I've come a long way since 1986, I guess. Again, you guys decide whether it's personal decay or evolution. Thank you.
Well, I certainly look forward, John, in the panel to discuss the victimization of corporations and whether or not the government is just too tough on these poor corporations. And so we'll have an interesting discussion, I think, on that subject. But next, we have our own Professor Stephen Smith. Professor Smith came to Notre Dame Law School, joined our faculty in 2009 from the University of Virginia, where he was the John V. Ray Research Professor. He earned his bachelor's degree from Dartmouth College and his JD from the University of Virginia School of Law. As a student at the Virginia Law School, he served as articles editor for the Virginia Law Review and was inducted into the Order of the Coif and the Raven Society. Upon graduation, he clerked for Judge David B. Santel of the U.S. Court of Appeals for the District of Columbia and for Justice Clarence Thomas on the United States Supreme Court. Before returning to law school or to academia, Professor Smith served in the Supreme Court and appellate practice group of Sidley and Austin in their Washington, D.C. office. He also served as Associate Majority Counsel to a 1996 House of Representatives Select Subcommittee investigating U.S. involvement in Iranian arms transfers to Bosnia, and also served as an adjunct professor at George Mason University School of Law. Professor Smith is actively involved in a number of community service organizations and civic projects. Professor Smith's area of research is criminal law and criminal procedure. He teaches courses on criminal law, criminal adjudication, and federal criminal law. The title of his presentation is Overcoming Overcriminalization. And with that, please give a very warm welcome to Professor Smith.
Try to do it this way. All right, so it's a pleasure being here. What am I saying that? I work here. But anyway, I'm at work. But it's great to be here, and thanks to JLEPP for putting on this conference. It's very important, and I feel like you know what analogy I'm going to draw if you're one of my students, right? I'm going to talk about The Matrix, all right, the movie, because it answers all the questions. And so the answer it provides here, I think, as to why I'm on this panel. All right, just like the oracle, whose job is to unbalance the equation, I think my job is to unbalance the equation. But before I get there, let me tell Professor Gallo, your generation had it right. Never trust anyone over 40, all right? And now you're over 40, so you're no longer trustworthy by your own metrics. And that's okay, I'm there too. But I want to talk about this important topic of white-collar crime. I realize I'm just that we're all just the appetizer. We've got our main course yet to come. So I'm going to view my role in this thing as sort of like a palate cleanser. All right, we've heard from experts talking about particular aspects of white-collar crime. And we'll hear more, I'm sure, about RICO and other things after I speak. So I just want to tee up some issues. Rather than answering any questions, that's no fun. All right, just tee up questions, get you thinking about certain things, and then hopefully we can have a very lively discussion with Professor Garule about some of the issues that have been raised this morning. And so white-collar crime obviously is a subset of crime as a whole, and prior speakers have focused on it, just like this panel dictated, as a topic in and of itself. And I kind of want to back away from that and suggests that white-collar crime really isn't all that special as a separate category, that it has the same pathologies that criminal law as a whole does, and so we shouldn't be surprised about the failings of white-collar crime. And I do want to emphasize the failings of white-collar crime because I think prior presentations have assumed that, gee, when they think of white-collar crime, who are we thinking about? We're going after Bernie Madoff, ran the biggest Ponzi scheme in history. We're going after Enron for cooking the books, all right? And those cases are out there, they're real, but those aren't the cases I'm concerned with. I think we should be concerned about a different set of cases, more along the line of what Professor Gallo is talking about, where the crimes aren't so clear, not just in terms of the facts, but whether the conduct in question actually is or should be a crime. Those are the cases I want to focus on, and I think we get different answers when we focus on that. Yes, perhaps we get the Madoffs of the world, but if we get a lot of ordinary business behavior and subject ordinary businesses to criminal liability for doing things that your average corporation does, things that aren't obviously illegal, all at the whim of a federal prosecutor, I think that's troubling. And it's troubling in the same ways that much of, I think, federal enforcement activities are troubling. So I'm going to try to unbalance the equation a bit, along with my idol, the Oracle and the Matrix. And so that's what I'm going to try to do here today. And so I've written on this board over here all the limits on federal prosecutorial authority. Right? And you should jot this down. All right, these are very important limits. In fact, I had to fill the entire board with things that prosecutors cannot do in the name of enforcing the criminal code. And on this board, I've written, you might have to look because there was so much to write here, I had to strain to write small. These are all the things legislatures in general and Congress does right when it comes to passing criminal laws. All right, so just two full boards here you want to keep in mind. I think these are true in general. They're especially true when we talk about white-collar crime. And so let me just scribble down a couple of things. I'm glad one of the other presenters has as warped a sense of humor as I do. Professor Kohler was talking last night with me, and she was saying, well, when you think about the definition of white-collar crime, you should think about the Chappelle Show. And I'm like, absolutely. Always think about the Chappelle Show. And there's that one episode you mentioned, which of course I think I'd shown to my class earlier this semester, where Dave Chappelle, his famous black comic, is trying to imagine. He said, well, we've got this world where we come down like a ton of bricks as a society on drug dealers and those kind of regular crime, I guess blue-collar crime. But white-collar criminals, we treat them with kid gloves. And what if we reverse that? And that became a very comic skit with ATF kicking in the door to the corporate CEO's house and tossing a grenade in, giving them public defenders and coddling the drug dealers. And so it was a very humorous skit, but it's very evocative, and it suggests kind of what's been going on in this particular area. So let me just erase some of these prosecutorial limits. All right, so now having cleared that space at the top of the board, let me just talk about two things. Overcriminalization on the one hand, and over-punishment. These are two features, two phenomenon that apply to blue-collar criminal law generally, and I believe they also apply, certainly lately, to white-collar crime. And when you put these two things together, what do you get? You get unbounded prosecutorial power. All right, and so what is overcriminalization? Overcriminalization, obviously as the name implies, suggests that there's too much criminal law, that we have too many criminal laws on the books, whatever too many might mean for that purpose, and that the laws that are on the book are too broad in their scope. Too many and too broad. And I should be using an orange marker because of my Virginia Cavaliers, but I've tapped it out, all right? They're in high demand, I guess, so I'm using blue, all right? So overcriminalization is this phenomenon, and we can see that in droves, right? By current estimates, there's something like 5,000 federal crimes on the books today, it should be revealing and troubling that when a member of Congress at a hearing asked an agent of the Attorney General's office to actually come up with an answer to how many federal crimes were, his response was, "We don't know," because there are just that many, all right? At least 5,000 crimes, and this is counting particular statutes. And in fact, that count, although high, is probably understated, because a number of groups have pointed out, and businesses know full well, that many administrative regulations are criminally enforceable. So if you look at rules and regulations issued by the acronym federal agencies, you get anywhere from 10,000 to 100,000 separate commands that, if violated, can be prosecuted criminally. All right, that's an enormous amount of law. All right, and it grows at a breakneck pace. The last study I saw showed that between the year 2000 and 2007, Congress gave 452 new crimes, almost 60 a year. All right, so the criminal code is enormous, it's large, it's sprawling, and it's constantly growing. All right, often not in response to demonstrated law enforcement needs, and some of the studies I've seen suggest that, of course, you get more crimes enacted in election years, suggesting that this is an electioneering by members of Congress, by trying to suggest, to signal to voters how tough they are on crimes. Now, if you just look at it from that perspective, okay, when you have so much law spread out over the 30 or so different titles of the United States Code, they're not all put together, they're not properly indexed, all right? So the drug crimes are in Title 21, you know. Title 18 is entitled Crimes and Procedure, but there are plenty of crimes not in Title 18, all right? The aviation code has some of the aviation-related crimes, so it can be a challenge just finding the applicable laws that are out there. And then you add to that the numerosity of it. All right, we see a situation where the crimes that are written are very unlikely to be defined correctly, all right, properly, with care, all right? Because that's kind of not the point. Pass the statutes, get them out there, get the credit from the voters for being tough on crime, all right? And the courts will sort out little niceties like what the words you use mean, such as when you pass the mail fraud statute and you don't define fraud. Well, the courts will figure that out, all right? And of course, before the courts can figure it out, what that really means is prosecutors figure it out. They make it up for themselves. They come up with their own interpretations of the law. They push them on courts, and courts then, after the fact, are forced with trying to decide whether to endorse those or not. Little wonder they usually tend to go with the prosecutor. So overcriminalization is something that's real. Overcriminalization promotes prosecutorial power because there's almost always going to be a statute that a prosecutor can use. And if the most applicable to convict you or your client, and if that most applicable statute doesn't fit, there'll be 20 other statutes they can pull in if they need to convict you. So I issue to my students from time to time the Lay's challenge. Like Lay's potato chips, according to the ad, were so good, they bet you couldn't just eat one. And I say, I bet you can't just violate one federal law. If you violate one federal criminal statute, you violated 20, all right, because the criminal code is so broad and so redundant in its reach. That gives prosecutors enormous power to pick and choose among the available statutes. And so, for example, if you have a credit card fraud situation, but it involves less than the jurisdictional minimum for credit card fraud, you can't use the credit card fraud statute, but then you can just use mail fraud or wire fraud or any other numbers of fraud statutes that are in the books. There's something like, there are more than 300 different fraud offenses on the federal books. So there's been a lot of legislative activity in this area. That's what I have in mind by over-criminalization. Over-punishment deals with penalties. And the penalties are quite high, and they tend to grow. And that's not surprising if legislatures want to signal how tough they are on crime. Passing new crimes is an important way to do that. Another one is raising penalties, and they've done this in a variety of ways. One are enacting all over the place mandatory minimum sentences. So upon conviction, the defendant shall be sentenced to not less than 5 years for using or carrying a gun during a drug crime. That 5 years is a mandatory minimum. It takes away the power of the judge to show lenience and to sentence below that limit. And of course, you can raise maximums. And there are other ways you can do it. Asset forfeiture. And those tend to add up to prosecutorial power, just as overcriminalization does, all right? Because these things tend to take away or limit discretion that judges have at sentencing and transfer it from judges to prosecutors. And and of course, no wonder, and prosecutorial power, therefore, ends in guilty pleas. So why aren't you going to fight the charges? Because you're not an idiot, all right? Bad things happen to you when you fight charges, all right? Because the choice is not, I would argue, well, let me create some room over here. The choice is not, I would argue, between a fair penalty if you lose at trial and a discount if you plead. If you're like me, you're thinking of that progressive ad. Discount! All right? Flow in those ads. But anyway, that's not the choice. You can get a discount if you plead guilty, and you get hammered if you lose. Just really harsh sentences. Sentences, to quote Judge Gleason, a pretty conservative district judge, former prosecutor on the Southern District of New York, he said, the sentences federal defendants get if they go to trial and lose are so high, they take your breath away. They are so high that no one, not even the prosecutor, thinks they're warranted. But they're allowed, and the prosecutor uses that in the club to say, hey, look, unless you want that to happen to you, there's only one way out, plead guilty, and lo and behold, more than 95% of defendants charged in the federal courts plead guilty, don't go to trial. Not just corporations, just individuals, all right? The power to charge you means you're going to prison. It's just a matter of how long. That's what we're arguing about. And that argument is not in the context of a trial, based on evidence from both sides and with a neutral arbiter, a judge or a jury as a decider, as Bush would say. No. This is prosecutorial dictates. This is negotiation, which is they make the offers and you accept. Now, you may negotiate somewhat, but ultimately, I don't think anyone would deny where the power lies. It's with the prosecutors. And that's why people plead guilty. And so, just to give you an example of this, I wanted to talk about the power that overpunishment can create. I want to talk about the 100-to-1 cocaine crack powder rule, which applied until a few years ago in the federal system. And then I want to talk about the mandatory minimum. First, the mandatory minimum. Okay, there's a defendant called Weldon Angelos. He collaborated with Snoop, and those of you who are under 40 can explain to the rest of them who he is. It's not the guy on Peanuts, the dog on Peanuts. That's Snoopy. That's something else. But this guy, he collaborated with Snoop. He had his own rap music label, lived in Salt Lake City, and sold some weed, all right? And was caught by Salt Lake police and in several undercover sting operations selling weed. All right, mistake number one, or number two. Number one, living in Salt Lake in the first place, but that's another issue. So once you committed that mistake, sorry?
Wait a second now.
Is that where you're from?
That's where I'm from.
Are you kidding me?
Yeah, seriously.
All right, wow. Welcome to America.
Indiana?
No. Touche. Right. But anyway, So Angelo sells drugs, is caught selling drugs by Salt Lake police on a couple of occasions. He's also carrying a gun, which he has but is not using. He's not brandishing it or threatening. He just has it. I guess it can be kind of rough in Salt Lake City. I don't know. But anyway, so he gets caught those 3 times. Instead of Salt Lake police charging him in Utah courts, because all those things are a crime there too, just hand it up to the feds. Why? Because you've got ridiculously severe laws on the books in the federal system that you don't have in Utah, even much less in other states. He got convicted and got a sentence of 55 years. And that was the minimum, the mandatory minimum. The judge was a professor at the University of Utah, and I guess now is back there, but he's a very right-wing, law and order type person. He said this sentence, which he was powerless to reduce, was cruel, unjust, and irrational. And he had issued a 60-some page opinion talking about how murderers and rapists and some terrorists would get sentences lower than this, and this was the minimum this guy got. And it was the minimum because they had him on 3 924C violations, using or carrying a gun or possessing a gun during a drug trafficking offense. The first offense, mandatory minimum of 5 years. Every subsequent offense, mandatory minimum of 25 years. And we're lawyers, we can't do math, but all right, he got 2 of those. 25 times 2 plus 5 equals something, I don't know. But 55 years was the minimum he got, all right? He's not going to be eligible, he's not going to be released until 2051. He's already served 10 years, so that's a life sentence for him, even though he was 25 when it happened, all right? And if Judge Cassell, a right-winger, thinks that's cruel and irrational, it really must be utterly cruel and completely irrational. So this is what I mean by over-criminalization, over-punishment, adding up directly into enormous prosecutorial power. With apologies to Mel Brooks, it may be good to be the king, but it's great to be the prosecutor, all right? It means you win, all right? If the case is at all dicey, you wouldn't have to charge it in the first place. You've got discretion. It's like by baseball, if you could say, okay, pitcher, I want the pitch about this high, no sliders, just straight, lob it right about here. If you could call your own pitch, yeah, you're hitting that out of the park. That's what prosecutors do. If they're smart in the exercise of their discretion, if they get themselves into a tough situation, then you've got the hammers to use, of very high penalties, of the redundancy of the criminal code to use. All right, this is the backdrop. And so when we hear about disappearing trials for corporate defendants, that's absolutely true. Also true, however, more generally, all right? That is what overcriminalization and overpunishment do. And then if we look to white-collar offenses, I think we see the same basic story happening. We were lucky, in a sense, that it took so long to get to that state of affairs in white-collar offenses because, basically, as a society, we had other fish to fry. We were fighting proverbial wars against organized crime in the 60s. We were fighting proverbial, and I might say losing wars against drugs ever since. So we've been doing all these other things. We've been focusing on violent crime. All right, white-collar crime is very much on the back burner. And so you had hundreds of federal fraud statutes on the books. Some of them date back to the Civil War. The False Claims Act was enacted in 1863. All right, so these statutes have a long, distinguished heritage in the federal system, and they're there in droves, but they weren't really used because many of them have very low penalties until recently, and they simply weren't on the Department of Justice's radar screen. Of course, after Enron, all that changed, all right? And so mail fraud and wire fraud, the basic anti-fraud provisions that are commonly used in the federal system, until then carried a maximum penalty of 5 years. After Enron, that went up to 20 to 30 years. And since then, we've had special DOJ task forces. And so now there's this concern that it's quite the opposite of what Dave Chappelle saw prior to Enron. All right, we're no longer treating white-collar defendants with kid gloves. In a way, we're doing exactly what he wanted, except envisioned in that skit. Except we're not showing showing lenience to the other side. It's just, we've just ratcheted up and shown barbarity to white-collar criminals, the same kind of barbarity we show to blue-collar criminals. And we have just incredibly high sentences driven primarily by amount of loss guidelines that can drive up sentences to enormously high levels. And, you know, we're almost at a point where I just wonder, gosh, if you can sentence somebody for cooking the books to 25, 30 years, all right, for fraud, you know, gosh, and murderers and rapists get lower than that? Is that really rational as a society? Does that make any sense at all? So you've got those sorts of concerns. Another concern is the one I mentioned at the beginning. Okay, we've got this concept of fraud. But what does it mean? Congress never bothered to define fraud when it enacted the mail and wire fraud statutes. You might say, well, then we'll assume that Congress meant then existing notions of fraud. The Supreme Court rejected that view in Durland versus the United States and said fraud basically means whatever prosecutors think it means. They weren't that bold, but what they said was, look, fraud as used in the mail and wire fraud statutes is not limited to prior notions, concepts of fraud, and it includes any means that might be used to cheat people out of their interests. In other words, it means pretty much anything, all right? Then prosecutors say, okay, we can think up our own concept of fraud, and so basically, we think corruption is fraud. Because when you take a bribe as a public official without telling people I'm taking a bribe, and I do this in class, you know, it would be great if you had to do this. I'd just like everybody to know that I just took a $10,000 bribe to throw the next case. No questions, thank you. All right? And if you don't have that kind of humorous press conference, all right, you are concealing and therefore defrauding your constituents because you're not admitting that you're on the take, and you're not disclosing the fact that you're on the take deprives them of their right to your honest services. All right, so you've got situations here that prosecutors can actually to come up with what constitutes fraud. And just to close, I should stop soon, right? Two minutes, okay. So just a concrete example of this from when I was in practice. One of our clients was under investigation for fraud on Medicare, and they ran a chain of nursing homes, and the people in there were on Medicare, and you could do physical therapy activities with them, and those were reimbursable under Medicare. And if you did the stretching exercises with them individually 10 times, 10 patients separately 10 times, that's 10 separate episodes to bill to Medicare. And so they said, rather than going from room to room, doing them that way, what if we do it all together, have a group therapy session, and do it all the stretching exercises together? Is that one act of therapy to be billed to Medicare, or is that 10? And I guess it was standard industry practice to say, even if you do it together, as long as you're doing it for all 10 people, that's 10 different billable events. The Medicare reimbursement scheme did not have a means of counting one way or another. We did it the standard way, and some prosecutors somewhere in the country, I think Arkansas, decided that this was fraudulent and was going to have a grand jury. Well, I think that's a misuse of the fraud statutes to allow a single prosecutor to set standards for an industry with no guidance except whatever he thinks or she thinks is the right way to account for things. So I think overweening power is here. It's very real when you talk about corporations, because even if you win, you lose by being indicted. Arthur Andersen's no longer around. Last I checked, it won its case. Right? The conviction for obstruction of justice was overturned by the Supreme Court. That didn't bring him back in to being, so the consequences for a corporation are draconian. And I would argue there's no reason for corporate criminal liability. That's something we need to think about. I think that's a very live issue. All right, criminal liability is necessary for humans because we have bodies that can be incarcerated. And what do you do about a judgment-proof defendant, someone who's poor? all right? A fine won't mean anything to them, but you throw them away for 55 years, that'll mean something. You can't lock up a corporation. All you can do is fine them. And in that situation, why not punish the wrongdoing corporate officials and fine the company, or civilly? Why do you have a criminal sanction that can be used? The criminal sanction exists in federal criminal law, not by virtue of any considered judgment by Congress, simply because the Supreme Court in a 1909 case said, yeah, corporations can be held vicariously liable for torts, so we don't see any reason for not doing that in criminal law. And it's that sort of breezy analogy that has created this situation where a knock on the door by a federal prosecutor brings even the largest corporations in America to their knees, all right? And that's where I'll stop, lest Angela revoke my welcome, but thanks.
We're going to take a short 10-minute break, just if you want to go off. But please come back.
Sure you can.
You and I could get away with it.
You can get away with anything you want to.
I'm not tenured anymore. You live in an alternate universe.
That's good.
That's what you do. You didn't go over the wrong side.
I was always there, right?
He was always there. You grew up in an alternate universe. It's nice to hear. And I've got so that's Irish. And he has been jerked around. He's now been indicted. And the prosecutor wants to be able to that or pay large fines. And it is extortion. And he thinks it's extortion.
But he's not paid, right?
Well, not yet. He's crazy enough to fight it. My advice was be a corporation and go about your business. Doesn't have to do anything.
Right.
Go about your business. He wants to actually do it.
Well, you need people like that.
Well, now,
I mean, it's kind of scary when it doesn't work out.
he wants me to bring a retailer against the prosecutors. And I say, well, but the Supreme Court says prosecutors go next door. Right?
Yeah, I don't think any
Yes,
case.
yes.
Yeah.
We get consulted, really, so
Right.
whatever, prosecutors go next door. And he says, well, that's what they're doing to me. And I says, yes. But I'm here to obstruction of justice. What's obstruction of justice? I just thought it was kind of, when a prosecutor uses the criminal process to award a civil settlement, is obstructing the civil settlement. And if he does it 2 times, he's already done it once and got the grand jury dismissed, I'm going to say it's illegal. Because it's the regular way of doing business. See, justice is possible.
HJE.
Justice is possible.
Well, that sounds similar to the theory of there was a RICO suit against the Vatican, wasn't there, or something like that?
Yeah.
Concealing all these.
Stuff. Yes. Yes. And it's got a foreign side. And the prosecutor maybe has an unqualified good faith, not good faith, liability. If he's acting in the prosecutor capacity, you didn't even get into that. He's got an absolute defense to liability.
Your citizen.
Yes. Yes.
Well, that's a key point, yeah.
And
There's no civil remedy.
no.
And
Well, what you have to do is get him in the investigation. investigating now.
Probably not investigating this part,
George, no, it's divided. It's divided.
What's faster than step?
I tried to codify the code. You wouldn't let me do it. I'm innocent. No, well, not a lot of people don't get federal.
Oh, the commission? Were you involved in that?
I did. S1. That was S1.
Okay.
That got tagged with Nixon by the ACLU. We never got anywhere. And that bill was the most pro-civil liberties you can imagine. Because it would have taken all the federal criminal law and put it out where you can see it. In fact, the major objection to what we were doing is that it was outrageous. And my answer was, look, it's only the present law. If you agree with that, the other time to do is, let's go through it, cut it out.
We've been on other things, right, like taking the jurisdictional outside of the definition of individual offenses and have some separate provision.
Well, then you wouldn't have mail fraud in 15 different versions. You just have fraud, right?
Yeah, one statute, right?
For fraud.
And then the jurisdictional hope would not be part of the offense, you just move that.
Right, and so you only have one statute. Part of your problem
Exactly.
is the way you define federal crimes is the jurisdiction. So if it's a bank, if it's a letter, if it's a wire, if it's a travel, it's all separate offenses. The answer to that, though, is when it gets into sentencing, it's only one offense.
Usually, right.
Yeah, usually one offense. But you're right. What's the economic impact of a crime? You know what you're supposed to do. Really? My governor, Sigmund, was alleged to have taken over to buy 500,000 crimes. That's where he put it. And so now his measure of injury.
You get a quick profile?
No, not really. He knocked it out. I mean, it's a long story short, but look at it. He got measured by his property law. When the worst case scenario, it was a all of those hundreds. What's the difference between the property and the income? Right. What did Keating say? Well, yeah, but I mean, what did Keating say? Of course I expected them to take action based on my contributions. Of course. That's what you're doing. What do you want with it? Yes, lots of be done.
Do you think I should ever take out
Being able to do that is like being on America. I was one day here in Stanley, once John called before, so it's really and then my own column house.
Okay, I think we're
So the answer is the work with as long as you can follow the work with all that time. In fact, we use it in the state of mind. Work its way into legislation. And this, and I don't think.
So what happened? Did somebody objected as last time?
Nixon. Yeah. First of all, they got because I had to get one. The Republicans are in the House. I mean, in the Senate. Oh, yeah. So did he. And then he got push it. It's politics, but we can't think about politics because if we lose the system we have, we'll end up with a good system. I'm corrupt.
Texas.
Second one is, are they here? The third one is, are you in fact listening to that? So it's like it's some of them.
Here's one. Where do you? Maybe it's just. It picks up automatically, I think. Hello? 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 Testing? Okay. Yes. If we can have, we're going to have all six
Does it
people.
matter where we sit?
No, you can have your choice. And we're going to have students be able to ask questions through here, and I think Professor Gurley will be back here.
Okay.
Excuse me. Well, we need the mic for the recording. Would one of you guys mind handling mic duties on this side? Because I'm going to be taking pictures. More on that side.
I'll do it, actually. Are you going to ask a question? '57 next week during the half marathon. Yes. Yeah.
Okay, why don't we get started so we can keep on schedule? I'd like to pose two questions, and after the response to those questions, I'm going to open it up to the audience for questions from the students. First question, and it's really more of a kind of a comment question. It seems that the symposium is kind of shifted. I see this kind of developing theme here from white-collar crime to a kind of an emerging theme, and that is that prosecutors are bad. And prosecutors are bad. They do bad things. Corporations are victims of prosecutors doing bad things. And prosecutors seek barbaric sentences to impose against these innocent corporations. And so let me pose my first question to John Gallo. With respect to your comments and your presentation about criminal corporate liability, and you make the point that it's enough for a single employee to commit a single crime acting within the scope of his corporate duties and responsibilities in order for the corporation to be held criminally liable. Well, it seems to me, first, I don't know that case. I mean, it seems to me that that's a very, very rare case where a prosecutor is going to seek to bring a criminal indictment against a corporation for one of its employees engaging in a single criminal act committed within the scope of his or her employment. So I kind of place that on the very far end of the spectrum. Is it possible? Is it conceivable? Perhaps. Does it happen? As a practical matter, I think it's extremely, extremely rare. On the other end of the spectrum, I see corporations, specifically banks, and I could list at least 7 or 8 that in the last 4 or 5 years have engaged in deliberate, willful efforts to avoid economic sanctions, including economic sanctions against Iran. These are corporations that have put profit ahead of national security. These are corporations that have decided we're going to do business with Iran regardless of what the law says in order to reap enormous criminal profits. And with respect to those corporations, the way that they were dealt with by the Department of Justice was not to be indicted, but instead to be permitted to enter into a deferred prosecution agreement. And at the end of the day, they were permitted to pay a fine. And at the end of the day, we don't even know if that fine amounted to the illicit profits that the banks generated from evading the law. And the justification for the DPAs, and this goes back to a point that you made in your presentation, is this concern about the death sentence. That if a corporation is indicted, then the corporation is going to fail, the corporation is going to go under. There's references to the accounting firm that did go under. That's cited as the example that it's always going to happen if you indict the corporation. And then here's my question. Doesn't that create a perverse system of justice, a dual system of justice, where if you're the low-level drug dealer, selling marijuana, you get 55 years minimum mandatory. But if you're the corporate official, the corporation, and you're engaged in illicit activity over multiple years, thousands of transactions, deliberate, premeditated, willful, nothing happens. A fine is imposed, and guess what? The shareholders are punished for that fine, not the corporation. So I think that there is a disconnect here, and where you got the low-level drug dealer getting 55 years, and you've got the corporate wrongdoer basically not being punished at all. And the concern that I have is that doesn't that undermine the public's confidence in the criminal justice system? And doesn't that create a dual system of justice? Your thoughts, comments?
At least as long as the question.
Thank you, Bob. First orienting towards my thesis. My thesis has to do with not individual corporate officers. Jimmy, so the corporate officer that you've identified should be prosecuted, in my view. And so, if the individual corporate officer that committed the fraud at Countryside or B of A or JP Morgan Chase, those guys should be prosecuted individually. The question that I was focusing on has to do with whether a company should be held liable. And you're right. You're right. It is rare for the Department of Justice ultimately to seek an indictment of a company where the proof is a single corporate employee committed that crime. That is rare. What is not rare is for, in the course of negotiations prior to that, in a civil context where there is a parallel criminal investigation, for the Department of Justice to de facto leverage the fact that they could prosecute the company as a leverage point to get a significant civil settlement. So, in the example I just gave, in that example, there was what I would characterize as thin corporate case against anyone in the company. That was the leverage point. So there were allegations about senior people, but it was an extremely thin case. But whether you leverage the fact that you have a single employee among hundreds of thousands, or you have a as Professor Smith put it, abstract concept of fraud with circumstantial evidence of it that you leverage. Either way, my theory is the government should not be in a position to be able to leverage those theories for, 9-figure settlements, now 10-figure settlements. So that's my concern.
Well, let me just add to that, and this goes to comments that Professor Smith made at the end of his presentation on the question of should there be corporate criminal liability at all. And, you stated that, certainly the senior level bank officials should be prosecuted if the bank official engaged in willful criminal violations of the law. But I think that a compelling case could be made for going after the corporation as well, because if these employees are acting on behalf of the corporation, and if these employees are generating enormous illicit profits for the corporation, not necessarily for themselves, maybe they get promoted, they get to keep their job, but the money is really benefiting the corporation. And if the corporation was negligent or reckless with respect to compliance with federal regulations, due diligence, it seems to me that there is some moral culpability there. And at the same time, I think that there's some equity there in holding the corporation liable, because the corporation ultimately is benefiting financially from the criminal acts of its employees. And so I don't think that it is necessarily enough to simply prosecute the corrupt bank official. I think that prosecution should be on both levels. You prosecute the corrupt bank official, and at the very least, you disgorge the illicit profits from the corporation. And by the way, I think by prosecuting the corporation as well, hopefully you deter the corporation or encourage the corporation from implementing and executing a more robust due diligence program. So I'll pose that question to question to Professor Smith.
That's right. So it raises the question about, is the corporation truly a separate entity or not? And a corporation can't act except through its agents and its officers and employees. And if those officers and employees aren't deterred by their own potential criminal liability, what added deterrent is there for them in holding the corporation potentially liable criminally? Secondly, because you can't incarcerate a corporation being an abstract entity, all you can do is fine it, and those fines or the ruinous losses that happen if it goes out of business are all visited upon the shareholders of the company, who are not the ones who are involved, who typically have no way to manage or supervise what the corporation is doing, and they're innocent. Innocent shareholders are bearing the cost. Definitely there should be some financial accountability to the corporation if you can say it has a culture of non-compliance. But you don't need the criminal process to do that. Civil sanctions, civil fines can be enough. And in fact, I might argue, if we have your point of view about corporations, criminal liability probably doesn't go far enough to serve your goals, precisely because they pay and they get out of jail they get out of jail without a prosecution. And so there's no public accountability, no public shaming. They reach these side agreements called deferred or non-prosecution agreements with the Department of Justice. That avoids the indictment or the trial on the indictment in the case of a DPA. And maybe there's some positive good that would come from suing a Bank of America in a civil court and saying, no, we're going to prove you broke the law and you had a corrupt culture, and we're going to hold you accountable in the light of day. I think that would go farther towards accomplishing your goal than this.
It just strikes me that that the corporation should not be permitted to keep the illicit profits that it generated through the criminal activity of its employees. And so when you punish the individual employee, that doesn't go to the issue of disgorging the illicit profits. And when you punish the individual employee, that doesn't necessarily deter or encourage corporate officers, senior corporate officers, to institute and implement a more robust due diligence program in compliance with federal law to prevent this from happening again. And so that's kind of, there's deterrence, certainly specific deterrence regarding the individual, but I'm also concerned about deterrence regarding the corporate culture and moving the corporation away from a culture of impunity and a culture of corruption to a culture of compliance. Well, with that, let me open it up to any questions from the students in the audience. So let's hear from you regarding any of our speakers or any of the issues raised. What about you, Ben? You have any thoughts on anything? Ben's been involved in some issues related to corporate prosecution, corporate criminal liability.
I guess for Professor Gallo, just because you're kind of on the front lines dealing with the corporations themselves, as much as you can, could you speak to maybe how these deferred prosecution agreements, because there have been a lot of them over the past decade, how this is affecting your clients? Are they coming to you concerned about these, or do they see it as just a cost of doing business now that they can engage in this criminal conduct and say, okay, at some point we have to come forward to the Justice Department, admit what we did, pay back some money, and just move forward, but we're going to be fine individually. So how is it affecting corporate culture, I guess, is my question.
Well, I don't know of any companies that have a DPA or have had to negotiate for a deferred prosecution agreement that have, after having done that, look forward to the next DPA as a cost of doing business, because they're exceptionally onerous. So what you do is, first thing you do is you admit liability. And so during the course of the time of the DPA, let's say it's 5 years, you admit liability before a judge. The judge doesn't enter a judgment against you. The judge says, okay, we're going to defer a decision on this case for 5 years. We'll see you in 5 years, essentially. There's a case that's filed against the company XYZ. XYZ says, we had an employee, he did it. So if in the course of that 5-year period, the government, in its singular discretion, determines that the DPA has been violated, they can bring a motion in court to there's been a violation of the DPA, and that judgment should be entered against the company, and there's no defense. The company has no defense because it's already essentially pled guilty. It's just judgment has not been entered. That is a horrible existence for a company to be under for 5 years. So that's the first thing. Second thing is every single bad act that occurs at the company for 5 years has to be reported to a monitor. So if somebody makes an allegation and it's substantial enough, even before you've investigated, you have to report it to a court-appointed monitor. You're obliged to cooperate with the investigation. There's essentially no privilege attaches to any investigative work you do, and on and on. And you pay a fine, et cetera, et cetera. And there's more onerous compliance requirements. You pay for the monitor, okay? So there's a big case involving Apple where the Second Circuit actually reversed the decision by the Southern District of New York judge to appoint a monitor in a case. That monitor, it costs tens of millions of dollars a year to have a monitor. So, which usually come from large firms. So, bottom line is, no firm no company I'm aware of that gets a DPA says, hey, that was worth it. Let's go back and do again what we just did. So we can get it, then we'll just have another DPA, no big deal.
Okay, question? Mm-hmm.
So my question is changing track a little bit here. Sorry about that. I think it's on now. So my question, I'm directing this to Dr. Kohler. In your presentation, you had mentioned about kind of changing the tone at the top, sort of an internal cultural shift. And I was wondering if you could maybe put that in context to see if that jives with what the theme has been going now with sort of, an overbroad prosecutorial discretion, if the tone at the top would be better fit for governing these types of issues. And then maybe if the two gentlemen from the National White Collar Crime Center could even respond to kind of, given the direction of where white collar crime is going, I mean, do the statutes, is it just because the definition is malleable at this point or changing and evolving? I mean, is that part of the problem, or I guess a statutory fit? So both kind of the internal side and then also the government and policy side.
Well, honestly, as a pragmatist, I think the tone of the talk is kind of a catch-all that says, if this is how you demonstrate that you're a compliant culture, you demonstrate that your top managers, your board, your senior executives publicly coerce or convince or condone compliant behavior. And that you demonstrate that throughout manuals, through training, through awards for people for being compliant. And again, I think it's more of a, this is how to demonstrate that you're compliant and that you're building a compliant culture. But I think everybody knows that other things go on in corporations. And there is also this culture of deviance within organizations. Organizations exist to survive. Yeah, they might have a DPA and want to get through it, but they're always doing risk-reward calculations. Whether you're talking about Ford Pinto or Toyota's accelerators or even NASA with their O-rings with the Apollo or the space shuttle disasters. There's things going on within corporations that can't be addressed with tone at the top. It's this underlying subculture within these organizations that say, do whatever it takes. And it's all monetarily based. Whether it's to beat competition or to reduce costs or gain more profits for yourself. I don't think you can control that with a compliance type program or with catchphrases or slogans. I think it really just has to do with, are you monitoring the activities of your employees? Are you centralized enough to know what's going on within all these different aspects of your organization, and which is almost impossible when you're dealing with even international offices like something that was on the screen earlier from John Gell's organization. It shows how many different offices you have around the world. Well, how do you obviously know what's going on in each of those offices? You don't. You can't. But if you proclaim that you have a tone at the top, if you proclaim that you are following the letter of the law, and you know better what's going on within your organization and within your industry than the regulators do, you can at least portray an image of compliance. You can portray an image of proper tone at the top, while still getting away with your dirty deeds, if you will.
Well, when it comes to the statutory approach to handling copyright, I'd say the biggest problem we see is that what kind of exists in the businesses, and business is evolving constantly. The way we do business changes. These statutes don't change nearly as quickly. We do a lot of computer crime. The main computer crime statutes are from the 80s. If you're not using you're not going up your modem, dialing up your computer, they don't apply to you the way they are. There are some concepts that are extinct in the real world, which means you have prosecutors trying to figure out, hey, does this concept apply to what we're doing now? Usually we're going to use the system even remotely like that. And a number of other industries have similar problems. We can try to legislate how you should do it, how you should approach it, but the reality is that business has moved on, and we don't do it that way anymore. As they're trying to apply a model that moved to a system that moves on.
So do you think that this creates an issue of overbroadness that leads to the prosecutorial discretion, or do you think that it's even just not specific enough and it leads to more criminal activity, or both?
Both, really. I'd say you're giving a lot of interpretation to the prosecutor.
also think it's important not just to have a corporate culture of compliance at the top, but it's also important for regulators, government regulators, to do their job regulating. So much of this dispute, like the inner cynic in me says, is because the SEC fails to catch Madoff right under his nose, running the biggest Ponzi scheme. They fail to catch all of these frauds, and before the fact, when you can actually avoid the harms and keep people safe from the harms, and criminal prosecution after the fact becomes an excuse for their lack of stopping these things from happening. I would much rather, as an investor and so forth, who am I kidding, I don't need money to invest, but if I were an investor and if I did have money, I'd rather them stop the frauds from happening proactively rather than just after the fact punishing a bad actor or two and hoping there's some spillover deterrent effect. But I think, you talked about mortgage fraud as another example. And you know way more about this than I do, but it seemed to me that that was kind of a self-inflicted wound from the government's perspective. I mean, they pushed this whole idea of go out there and make loans. We want more and more people owning homes and so forth. And of course, like day follows night, if you're making loans to people with the weakest credit profiles, of course there are going to be more defaults and foreclosures. I mean, that's not a surprise. But then the government's shocked to find that gambling is going on at Rick's Casino. I mean, it doesn't work. I mean, I think the government needs to own up and take responsibility for its own actions rather than blaming corporations. They ought to blame corporations when it's deserved, but they need to take blame too for their lack of proactive enforcement activities. And I just worry that these after-the-fact prosecutions can be used to pass the buck.
Well, just to comment on that, I mean, just look at J.P. Morgan, who's now having to look at a $1 billion settlement for not dealing with Madoff suing them. Who's going to sue the SEC for that? I mean, they're almost going after a lot of these civil judgments or criminal prosecutions just to keep their organizations alive and keep telling themselves that they're doing the right thing. But when they're implicit in providing the tools and products, enforcing these on lenders, I mean, a lot of conventional lenders, for example, did not start doing subprime mortgaging. They just didn't want to take that risk. They thought it was too innovative. It just didn't fit with their way of doing business, and they didn't get into that kind of problem. But other newfound styles of banks and non-traditional lenders, grabbed onto it because they could get a bigger piece of the pie. And again, this was all pushed on them through legislation saying you need to make loans to these people. So I agree 100% that the government was very involved in creating this crisis, but it goes just so much further. It's like when you talk about Bear Stearns and about AIGs, some of them did get the death sentence, but a lot of their CEOs and other officers from their C-suites got jobs when they were bought out or went bankrupt. So, I mean, there really was no personal loss for a lot of these people that were involved in this mess, whether they were from the credit agencies or whatever.
And when you look at it, you can talk about culture at top, and you've got to have like a compliance officer, and you create a position. We want you to comply. Yay, obey the law. Hip, hip, hooray, obey the law, but make money, all right? And obey the law, but your bonus is tied, your compensation is tied to the results. And so the more results you get, the more money you bring in, more money for you. We want you to obey the law. I mean, that's fine when it comes to cooking the books and obviously illegal things. But again, I would say some of these things, these controversies don't involve obviously fraudulent, obviously wrongful activities. And then the mixed messages border on they're on the border of cognitive dissonance, because I don't want to do anything wrong, but on the other hand, I need to make money, I need to get results, our share prices need to be up, and if it's not clearly illegal, shouldn't I be allowed to do it? Well, you do that way, you get indicted or something, then it's like, how dare you, after the fact, do that? I mean, so I think there's a real problem. I mean, so culture at the top is important. Yes, you want to encourage compliance, but you also need to understand corporations are in business to make money, and it's dangerous if prosecutors, after the fact, can take ordinary behavior that isn't obviously illegal and have it declared illegal by fiat. That's not good.
Well, let me give you an example of a case that wasn't. I'm sorry. Sure, go ahead. Absolutely.
I'm looking at the time. sure, the government should take a certain degree. Why don't you blame it on the politicians? For example, when I talked this afternoon, Congressman Cox, basically a right-wing Republican, was put in charge of the SEC, and the SEC was a cop not on the beat because of the ideological presuppositions that the free market governs itself best. And we found out in the crash that the free market doesn't govern ourselves. And nobody's gone back and charged Representative Cox. So ideology is playing a role in here, economic ideology. And people don't admit that their economic ideology was flat out wrong. So I think if you're looking for blame, we've met the enemy and the enemy is us. But that doesn't get us anything. Is there anything we can do step by step to change it? Well, the answer really is yes. But there is a problem with putting too many regulations on people, for example, to control corruption. And one of the consequences of that, who in their right mind wants to go in the government anymore when you have to fill out all those folders, those files? And the internet collects everything you've ever done. Don't we have this notion of rehabilitation sometime or change? My good friend Gallo was clearly going over to the dark side. And I would say that my good friend Steve is going over to the dark side too. That would be inappropriate. It would not be PC. So I just have to suggest that he's been in an alternative universe from the beginning. He never crossed his mind. He just is not in contact with reality. But it's good to hear it, because then it makes me modify what I have to say. We probably can do little things, and we ought to do them, but we ought not to expect fundamental changes in human nature. If we think that the purpose of the criminal justice system is to control crime, we're mistaken. The criminal justice system is to isolate dangerous people and lock them up. And it is to act out in public what our morals are. It's not a good thing to rape a lady. And if you're going to do it on a serial basis, we're going to put you in jail forever. If you're going to do it as a student, invading somebody's consent, well, maybe it's not the same thing as a rapist. We shouldn't lock you up forever. But we probably ought to have a ceremony called a criminal trial in which we declare what you did was wrong. We're changing our understanding of the interrelationship between men and women from Tarzan coming in the window and raping to interference with consent. That's an improvement. But we've got a problem. Now it's he said, she said. And if it's a rape case, the bad result for the man is not terribly good. And if our understanding of consent is moving over time to be like the selling aluminum siding, you have 48 hours to decide that you didn't consent 48 hours previously. That's not terribly good, and we don't move into that. I don't want to fall back and simply say what we're describing here is the human condition, and it's not going to change anytime soon. I want to look at every one of these cases individually, not to make general points, but to find out is I can learn anything in this case to modify things. I'll make one last point and I quit. John, I have a case right now where I am representing a guy who allowed too much dirt to remain in a place where water might come. And the EPA has indicted him, basically. And it's a best example of extortion by the government in order to obtain large sums of money from this guy. And he wants to fight. And my advice to him is have a small subset of the corporation that doesn't do the government anymore, plead guilty, pay the fines, and go on. prosecutor who acts in charging decision is absolutely immune from criminal or civil responsibility. That's something we ought to change a little bit. On the other hand, it would deter prosecutors from acting when we want them to act. We've got choices to make in that area. I can't wait until I get to Sarah Newman. Hopefully it's for now.
Any more questions from, yes?
So a lot of you have talked about prosecutorial discretion, how it's excessive, and I'm wondering if anyone has any solutions for limiting prosecutorial discretion or somehow improving the prosecutors in our system or their judgment.
A number of ways you can look at discretion, and one of my favorites is the hydraulic displacement of discretion. How if you control discretion in one point of the system, it's just going to pop up in another. So when you talk about prosecutors' discretion to charge or not charge, and which forces the judge's hand to sentence in a given way in the 55 years, the prosecutors still had some discretion on what to charge, and what charges to bring. So when you put mandatory sentences on, you reduce some discretion from the courts and from corrections, and given a lot of it back down to the prosecutors, back down to law enforcement. If you limit things at the prosecutor's point, again, the pragmatic or the cynic is going to say it's going to move to someplace else in the system. Our system is built on discretion, and I think there's ebbs and flows as to who gets to hold that much discretion throughout the system over time. So I guess my answer is I don't think you can change it. It's just going to be switched. It's going to be changed to somebody else in the system.
Here's another example of if you wanted to limit prosecutor discretion. Okay, how would you do it? Would you give the judge an opportunity to review prosecutor discretion? And if you did that, we got this thing called separation of powers. The more you put a judge in on everything that somebody in the executive does, the more we're run by judges. And frankly, I don't see anything in the judiciary that indicates that they're capable of making better prosecuting decisions than well-trained prosecutors. I'm appalled that you got that kind of discretion, John, when you were 28.
I'm not appalled too.
That's a defect in the Department of Justice. And I'm appalled that a prosecutor, any place, any time, could make the kind of decision that would have an indictment come down that destroys the country. Now, first of all, you and I both know that if a grand jury subpoena comes out, you can call the prosecutor, and the prosecutor won't talk to you, you can talk to the main justice. And if before you get indicted, you can make a presentation to the Department of Justice to prevent the indictment. And I happen to know that in the accounting case, that had been done, and they passed up the prosecution, and then they turned around and did it again. So what was the prosecutor do the second time around? He said, look, this is terrible. You guys should not do this again. If you do this again, we're going to come down with a hammer. They did it again. I think that prosecution was justified. And in fact, I read the Supreme Court, same case that my good friend Steve did, and I think the Supreme Court let them go illegally. They misconstrued the record. What they required to have been done had been done in the record, and therefore they shouldn't have dismissed it.
Yeah, so let me just add a couple things quickly, if we have time.
Yeah, go ahead.
Obviously, I think it's important some kind of remedy after the fact for abusive prosecutions could be enormously helpful. I mean, prosecutors are the only figures in our government that you just cannot sue, no matter how abusive their exercise of government power is. And I think it's pretty scary that they have unchecked power, but that's one thing to do. Another thing to do would be to have narrower, more targeted criminal codes. In other words, criminal codes that make sense, that have reasonable penalties, and that defines clearly what we want to punish. Back in the common law days, we talk about prosecutorial discretion as if it's this inevitable thing. There was no prosecutorial discretion in the first 100 years or so of the country. Why? Because you had much narrower criminal codes, and they dealt with pretty serious things. And so, yeah, you're not going to pass on a rape or a murder, or if that's your criminal code, very serious crimes, there's no role for prosecutorial discretion. It's simply, did the crime happen? Can it be proved? And then we go forward. Of course, we live in a more complex society now. Criminal codes are going to be larger, but they don't have to be as blunderbuss as especially the federal code. The federal code, by the way, I think is exceptionally messy. A number of states have much better codes. A third thing we need to do, I think, is to depoliticize to the extent possible charging decisions. State prosecutors are elected officials. Right. They are politicians. Of course, that's not true of federal prosecutors, but they're still very sensitive to politics through the Attorney General and the presidential administration, and that can be a bad thing. All right, and I've had LLM students over the years from Japan, and they're always horrified to learn how political criminal justice is in the United States. They say in Japan it's not like that. I mean, people don't run on how many convictions they have. I mean, it's a deliberative, intensive process. I hear that from lawyers in France too, and in Europe more generally. We are exceptionally political, and no wonder, and little coincidence, we're also exceptionally draconian in our approach. We're the only one who has a death penalty among our Western allies. We were the only ones who gave life without parole to juveniles. I mean, we are barbaric when it comes to criminal punishment. I mean, Europeans look at our system with horror, all right, and we need to do something about that. And I think if we did some of those things, much less all of them, and I just want to say, prosecutors are not bad people. I mean,
they just do bad things.
They just do bad things. Right? So it's like from the.
I feel better.
The other quote from Casablanca, the woman says, "Well, I need to know if I can trust the French prefect." And he said, "Is he a good man?" And he said, and Bogey said, that's Humphrey Bogart, said, "He's just like any other man, only more so." And that's my act about prosecutors. They're just like anybody else, only more so.
So I have a follow-up question to that. Go ahead.
First two comments. The question, one of the best questions I've ever heard. I don't know who raised you, but the second thing is, my answer is get rid of the sentencing guidelines. In 1987, when the sentencing guidelines were passed, remember the question, sir? But when the sentencing guidelines were passed, it was a dramatic shift in power from judges who had complete discretion to impose a sentence, and the prosecutors could only argue for a sentence, to an environment where the prosecutor's decision as to what to charge and whether to charge was determinative of the sentence. And when that happened, it consolidated power with federal prosecutors in a way that has led to a lot of the problems we're talking about. I think Professor Smith touched on this, but real briefly, if an environment where I, as a criminal defense lawyer, know that, okay, I have Jimmy's prosecuting my client, and he has a view and I have a view, well, he can present his perspective to the judge, and I can present my perspective to the judge, and a third independent person will make a decision. It's very different than if he says to me, "John, I'm going to charge your guy with a 924C, which is a 5-year mandatory minimum." If my guy's convicted, he goes to jail for 5 years, period. No matter what the facts are.
Yeah, John, I was involved in the sentencing guidelines, and the sentencing guidelines was an effort to limit the discretion of judges, and rightly so. They made them mandatory. Bad idea. That got corrected. They're not mandatory now. Right. So you argue on sentences, and if you think one thing and another thing, the judge thinks the third, you take it to the Court of Appeals. Why should we have purely discretionary sentencing of the judges? Not one country in the world follows that system. They all have appellate review of sentencing. Why should the trial be about search and seizure rather than guilt or innocence? Why should the sentence not reflect sentencing guidelines of some sort? So get rid of the sentencing guidelines, it's a bad idea. The sentencing guidelines we have now are pretty good. The mandatory minimums are the problem. And the reason why we have mandatory minimums is the Supreme Court is willing to stick its nose into anything but mandatory minimums. They ought to declare them unconstitutional, and we can move on. It's the judiciary's fault.
He gets the last word.
You still want it? Okay. You keep on track? Okay. Well, with that word, then, we're on schedule. And so I want to thank our speakers and for a very interesting and enlivening discussion, very insightful, very substantive. Thank you very much. And I think we're going to break now for lunch, and then we'll go ahead. And then I'll turn it over to Adrienne, and she can give us an update on the schedule.
Thank you, Professor Gruley. I just want to thank all our panelists and our speakers. We have gifts for you, so I'm going to give them to you now.
This is the presentation.
Everybody for coming now. We're going to break for lunch, so we'll be back here at 12:30 for our keynote address. So hopefully you can all make it. Thanks.
I feel like I'm heard enough in the apartment. I'd like to be more heard.
Yeah, I think so.
I'm not saying too quiet. I'm just not heard enough.
Afraid that people wouldn't ask
Yeah.
anything. Yeah.
What? Oh, you did?
They actually answered everything.
What is the cost of living in the West Virginia Spring Law?
Dirty dog gets read at 11:30.
Yes. No. Hey, always speak last, right before the jury.
I'll see you. This application or something. Where are you guys headed to? All right, I'll see you at 12:30 or so, right? You got some good stuff planned? Yes. Great.
Okay.
would you let me know?
Yeah.
Thanks.
I'm just moving the chair. Probably. I'm going to move the water bottles, though, I guess. I'm going to try to figure out how to move the screen up, too. What? I'm going to try to figure out how to move the screen back up. Does he have anything put on it? Surprising. Thanks, guys, for coming. Are you wearing a name tag?
Pocket square.
Oh, it's my poor eyesight, so.
Pocket square for business casual, I like it. No, I appreciate the effort.
Well, no, I just wanted it to look good for you. You said so. You didn't like my email about live.
Does anybody know how to raise the screen back up?
You didn't like my email about live tweeting or sort of.
I was trying not to look at my email too much. I was just spending the.
No, you should live tweet. Retweet like at JLEPP, hashtag JLEPP Symposium.
Yeah, we got a poster too. I'm serious.
People to go to Federalist Society. Who was speaking to them?
George Weigel. He's a scholar in the Ethics and Public Policy Center, which makes it even more ironic.
Doesn't have Blakey's name or anything.
They have Chick-fil-A.
Well, that hurts.
That's what she's telling people, and I was like, well, what if they just get Chick-fil-A and then come into a here Lakey? She would actually yell it. She told me once that she, this was like recently, someone took Chick-fil-A and she saw them leave, like the moment they was like, and she got it.
Someone yesterday totally just got pizza.
Yeah.
It's like, we're so accountable to something. I'm going to try to draw them here.
It's a 4-course and a lot better than one.
Oh,
Yeah.
And it's more filling. Oh, so I guess we didn't get any COEs. Oh well.
Yeah.
This is for my client.
obviously never done anything quite like that, but it was a fun experience. It was something completely different. No stakes. No way. Starting. Oh, no. That's oh, shoot. I was going to be Joe. I'll pick like
That's all right. No, that's good.
You say you do not have a PowerPoint.
No. Nope.
Thanks everybody for coming and joining us for our afternoon session. Before we get started, I just wanted to thank our morning panelists again. I'd like to say thank you to Dr. Kohler, Dr. Cliff, Attorney Desolé, Professor Gallo, Professor Smith, and I'd especially like to thank our moderator, Professor Gurule, for leading us this morning. I'd also like to thank Adrian again, and I'd also like to thank all of our co-sponsors again for your support, and without you, this would not have been possible. It's now my pleasure to introduce Professor Blakey. Professor G. Robert Blakey is the Notre Dame Law School William J. and Dorothy K. O'Neill Professor of Law Emeritus. Professor Blakey is the nation's foremost authority on the Racketeer Influenced and Corrupt Organization Act, also known as RICO. And his extensive legislative drafting experience resulted in the passage of the Crime Control Act of 1973. Professor Blakey served on the Notre Dame Law School faculty for more than 30 years and taught in the areas of criminal law and procedure, terrorism, and jurisprudence. He has been personally involved in drafting and implementing RICO-type legislation in 22 of the more than 30 states that have enacted racketeering laws. He frequently argued in or consulted on cases involving RICO statutes at both the federal and state levels, including several cases before the United States Supreme Court. Professor Blakey has considerable experience in federal and state wiretapping statutes as well. He helped draft and secure passage of Title III on wiretapping of the federal 1968 Crime Control Act and was personally involved in drafting and implementing wiretapping legislation in 39 of the 43 states that have enacted such laws. Professor Blakey extensively investigated the assassinations of President John F. Kennedy and Dr. Martin Luther King Jr. He served as chief counsel and staff director to the United States Select Committee on Assassinations from 1977 to 1979 and helped to draft the President John F. Kennedy Assassinations Record Collection Act of 1992. Professor Blakey earned both his law degree and undergraduate degrees from Notre Dame. Please join me in welcoming Professor Blakey back to Notre Dame.
I too should thank everybody for giving me the last word. I don't often have it. I have 8 children, and with 8 children in the house, you never have the last word. I did indeed head up the Assassinations Committee, but when we would go to foreign embassies, as we had to do, the State Department wanted us to be very clear that we were the United States Select Committee investigating assassinations, not on assassinations. In any event, I have a long paper. It has even longer footnotes. I will not burden you for the whole thing, but let me read a little bit of the introduction, and then I'll have some thoughts. In December 1939, Edward Sutherland, the sociologist, just coined the phrase white-collar crime in a short paper he delivered before the American Sociological Society. And that's a point to comment. In the paper, he raised the question, is instead of looking primarily at lower socioeconomic crime, murder, rape, and robbery, we ought to look at upper socioeconomic crime, white-collar crime. And he coined the phrase for it. And he identified a large number of major corporations that had repeatedly engaged in criminal behavior, which wouldn't seem to be out of the, well, he got all the evidence from newspaper and such. When he went to publish the book, White Collar Crime, he was prevented from doing so because the large corporations came in and threatened to sue the publisher. And the book did not appear in an unexpurgated edition. And he did it in 49, and it didn't come out till 1985, unexpurgated. That's the power of real organized crime. Let me repeat that. That's the power of real organized crime, preventing us as a community from discussing white-collar crime and identifying the perpetrators. The perpetrators can shut down the discussion, and effectively they did so. He sought to draw attention to the role of class in antisocial behavior. As he saw it, crime was primarily thought of as violent offenses, assault, robbery, and rape, committed on otherwise law-abiding citizens. And that really means, that's the uniform crime reports. Murder, rape, and robbery. That's crime. The uniform crime reports say what's not crime by omission. They don't talk about white-collar crime. They don't talk about organized crime. They don't talk about terrorism. And we ought to talk about all in a community. The uniform crime reports are, in fact, one of the ways we hide the nature of crime in our society. And they are as ideologically driven as they are an effort to explain a social phenomenon. Society properly dealt with them by arrest, conviction, incarceration. In fact, members of the lower socioeconomic class tend to commit these offenses. It doesn't say that, it just works out that way. When I was young, a long time ago, and like a lot of teenagers, I didn't have the same sense of right and wrong. And we used to drive around in cars, like teenagers do now. The price of gasoline was 15 cents a gallon. But that was more than we could afford. But we knew of a gas pump on a construction site that didn't have a lock on it. So we would go over and fill up our car. Had I gotten caught for that, and I didn't get caught for that, given my socioeconomic class, I would have been taken home to my parents. And actually, I'd have been more trouble for my parents. That could have been everything the police could have done. If my skin color had been black, this is in the South in the 1950s. If my skin color had been black, I would have been arrested for grand larceny, and the likelihood is that I would have gone to the state prison. And with the state felony conviction for larceny, could I have gotten in law school? Could I have gone to work for the Department of Justice? That's an example of the meaning of white-collar crime. Crime is a social phenomenon that we put labels on and then enforce them with. There's no such thing as the entity crime. That's why, again, I'm digressing, but I think it's a valid point. I've been to a lot of conferences on organized crime, and the first 20 minutes or so is spent in worrying about the definition of organized crime, as indeed we were worrying about the definition of white-collar crime. And after we get the definition, and there's no agreement on it, we go on ahead to discuss it. We don't pay any attention to the definition problem, and one of the reasons we don't pay attention to the definition problem is you can define it however you want to, not because it's arbitrary, but it depends on your purpose. You might have one definition of organized crime for annual reports on it, one definition of organized crime for prosecutions, one definition of crime for investigations. You don't have to have the same definition. It is the misuse of a medical model. If I want to find out what causes syphilis, I go look for a bug. And when I find out what the bug is, I zap it with penicillin. There's no bug to zap for organized crime. And there's no bug to zap for white-collar crime. Because there's no such thing as murder, rape, or robbery apart from the criminal code. And there's no such thing as white-collar crime apart from the criminal code. Let's just forget the definition. It is also a misuse of philosophy. Ever since Plato, we took the position that every definition had to be an essential definition, this and only this. Ostensible definitions, by pointing to what is a ball, what is a pen, this is a pen. Have I defined the pen? No. Have I pointed to it? Yes. That's how we learn language. And we do tolerably well with ostensive definitions. We can have ostensible definitions in white-collar crime control and in organized crime control. We don't have to have platonically precise definitions to do a tolerably good job. And we should not be sucked into a medical model, and we should not be sucked into an essentialist model. That was just a footnote. He argued, in fact, members of the lower socioeconomic class tended to engage in these fences. In contrast, Sutherland wanted to draw attention to the antisocial behavior by members of the upper socioeconomic class, including, he said, fraud, embezzlement, tax evasion, price fixing, and the like. He gave an ostensible definition: class and specific offenses. He made a study of offenses committed by 70 of the largest manufacturing, mining, and mercantile corporations in the United States. Over a life career of 45 years, the 70 corporations had an average of 14 convictions each. Instead of arrest, conviction, incarceration, law enforcement agencies, in fact, tended to handle the offenders in a civil process of complaint and injunction. Why? Why should price fixing, which is a form of theft, be a civil proceeding in antitrust? Why not make it a criminal proceeding? They have the option to go which way. Why should securities fraud be a civil offense? As well as a criminal, but they don't process the criminal. Had I been caught for stealing from gas, I would have faced a criminal prosecution. Why don't they? Because they are like us. They look like us. They go to the same country clubs that we do. They go to the same private schools, not public schools. We have two classes, at least two. We used to have the rich, the middle class, and the rest. Marx called it the lumpen proletariat. And increasingly, the middle class is drifting down into that, and the upper class is going on doing what they did. I think this data, you can correct me if I'm wrong. In the last 10 or 15 years, the middle class has lost approximately 26% of their income, and that 26% of the income has gone up to the 1%. Can we keep up that for any length of time? That's a different issue, but it's this issue as well. And some few offenders went to jail. Sutherland's book is universally acknowledged as the classic. It changed the course of sociology and legal scholarship down to our age. It is not as yet changed to any larger degree public policy, as this article shows in one small and largely unnoticed area of the law, RICO and securities fraud. And I will not take you down that path. It is arcane and technical. But what it illustrates is in 1995, Congressman Cox came out on the floor, said he wanted to reform RICO from being used in white-collar offenses. He didn't say that, but that's what he meant. What he wanted to do was take civil securities fraud out of RICO. Not criminal. That's done by the prosecutions anyway, and he wasn't worried about prosecution. Take civil out. And he succeeded in doing it, despite the fact that the presence of securities fraud in RICO's predicates, and 6 seconds on what RICO is, RICO says if you are employed by or associated with an enterprise, union, corporation, association, in fact, like the mafia, and you run that enterprise by a pattern of racketeering activity, which is more than 2 or 3, and the racketeering activity are defined by cooperation by reference of other criminal behaviors. Basically, the subject matter is violence, the provision of illegal goods and services, corruption in labor unions or in government, and, believe it or not, fraud. The fraud predicates were in RICO from the beginning. And when they began to be used against somebody whose name didn't end in a vowel, the argument was that RICO was applicable only to organized crime, which was a euphemism for the mafia. And that's okay because that's on Mulberry Street. That's not on Wall Street. And when it began being used, not because his language was broad, not because it violated congressional intent in the legislative history or on the face of the statute, but because it was against us, enormous explosion. And they tried to kill the statute once, and it survived, basically kill it, in the Senate by 1 vote. Then they took it to the courts, and they couldn't win in the courts. So what they did, they went out with a surgical strike. Now, I am not so arrogant as to think that the Wall Street crash was brought about by this amendment. But it's funny, if you look at when it began as soon as this amendment went through. Now, succession in events is not causation. I don't think it is. But it's an irony. None of the behavior on Wall Street, 78, 79, 80, could be handled by civil RICO's victims because of this exclusion. I'm going to tell you a secret. You can't do it under the federal statute, but those 35 state statutes have securities fraud as a predicate, and you can do it under state law. How about that? You can do it under 7. They weren't smart enough under this or any comparable statute, federal or state. They were not well represented by the people who put their amendment through, despite the fact that they probably were paid handsomely for it. People think that white-collar crime doesn't have an impact. Let me quote just once for you. The criminal justice system treats business offenders with leniency. This is from Coughlin, Illegal but Not Criminal, Business Crime in America. Prosecution is uncommon. Conviction is rare. Harsh sentences almost non-existent. My friend Steve Smith, to the contrary notwithstanding. Few individuals are imprisoned, and those who serve very short sentences. Many reasons exist for this leniency. The wealth and prestige of businessmen, their influence over the media, the trend towards more lenient punishment for all offenders, the complexity and invisibility of many business crimes, the existence of regulatory agencies and inspectors who seek compliance with the law rather than punishment of violators, all help explain why the criminal justice system rarely deals harshly with businessmen. This failure to punish business offenders may encourage feelings of mistrust towards the community, morality, and general social disorganization in the population. Discriminatory justice may also provide the lower class and working class individuals with a justification for their own violation of the law, and it will provide political radicals with the desire to replace a corrupt system. Let me repeat this. Political radicals with the desire to replace a corrupt system in which equal justice is little more than a spoken ideal. This book was not written commenting on what happened and they call it a recession. There are people who are still out of work from that recession. That looks like a depression to me. Look how we manipulate words. That book was written in 1977. It's before all of this. And nothing has changed. One of the problems with this is that among Marxists, there is a theory that if you raise consciousness, you can change the society. And what we're doing now is engaging in consciousness raising, drawing attention to something that was not previously seen and showing it to be inconsistent with our basic ideals of equal justice. Do we think we're going to change it? Do we really think we're going to change it? I hope not. What I don't want to spend the time doing is the technical question of the 95 Amendment. If you want to get into it, you can look at it in the paper, and you can look at it in the paper, and you can look at it in the paper, and you can look at it in the paper. It goes on and on and on. And it's just one more example of how I lead the paper off, which I am sometimes wont to do, with a quote from Shakespeare. "This is the time that the unjust man doth thrive." This is from The Winter's Tale. That's 400 years ago? 400 years ago? And it's still not different. Let's think together a little bit about what we talked about this morning. My first point, both John Gallo and Steve Smith sought to manipulate that's a bad word. No, sought to manipulate the conversation by taking examples. There's no indication in what they did that the example was representative. And it was of a sufficient number of instances that you could draw any conclusion from it. If you wanted to deduct something from it, it's an illicit major, if you don't have a representative example. If you want to infer something from it, it's an example of the fallacy of hasty generalizations. They do it all the time. They do it all the time. And the other side's not much better. Jimmy was doing it by talking about worst cases. Smith was doing it by talking about worst cases. We should be talking about a pattern of cases, examples. And if you can show me an example that is patterned and not extraordinary, then I should take action of some kind to do it, to do something about it. I think we need to talk about crime not simply in the categories that developed at the common law by the judges. Steve mentioned that there was no prosecutor discretion. At the common law, there were no prosecutors. The Attorney General could prosecute, but other than that, private victims prosecuted. There were no prosecutor discretion because there were no prosecutors. The role of prosecutors in this country is not an Anglo-American fact, a matter of history. We borrowed it from the French. We have a French prosecutor, not an Anglo-American prosecutor. And we have it with a French theory of responsibility in the sense that grand juries were a Norman invention. Anybody remember who the Normans were? You watch them on the TV all the time. Anybody watch Vikings? Oh, you guys don't. When you get out of here, you'll be able to watch television and enjoy things. Anyway, the Vikings came in and took over northern France, and they became the Normans, and then the Normans went over with a cover story from the Pope to take over England, and they did. And then they decided to divide England all among themselves. That's where we get real property from. And do you know why they built those castles? Because if they slept on the ground at night, an Anglo-Saxon would cut their throats. That's why they had to go up in those castles. And they developed a notion of a grand jury. A grand jury is a jury that comes around annually. The judge would come, he used to ride on circuits, and he would show up, and the grand jury would inform on all the felons, and they'd prosecute them. It was a mechanism to give to the sovereign information that he would not otherwise have. Prosecutor French, grand jury French. They're evidence-gathering techniques. And the grand jury, at least, is a constitutional institution that predates the Constitution. What it was incorporated into the Bill of Rights. It preexisted the legislature, the executive, and the judicial we have in the national Constitution. So let's talk about the kinds of crimes we have. We have street crime, basically lower socioeconomic class. We have organized crime, which is blue collar, and I don't mean just the mafia. Anybody can engage in organized crime. The Chinese do it, the Russians do it. In fact, the Russians are worse than the Italians ever were. Italian organized crime is just a tag you put on it. Joe Valachi, who was one of the first mob guys to testify publicly, said before the McClellan Committee, the senator I worked for, Senator, I'm not talking about Italians, I'm talking about criminals. And that's true. He was. So we have organized crime. We have white-collar crime. Let's take it as an ostensive definition of it. Or you could be with Potter Stewart. I know it when I see it. When you're describing major, large organizations who are able to have a larger impact on our society when they steal from us than all the thieves, all the burglars combined, it's money moving from the poor to the rich, right? Normally, street crime is money moving from the rich to the poor. They don't rob people that don't have money. Why did Willie Sutton rob banks? Because that's where the money was, so it's said, by a newspaper reporter who covered him. He never said it. So here we have street crime, we have organized crime, we have white-collar crime, and we have terrorism. Those are our problems. The criminal justice system is one among many tools that we can use to deal with them. It is probably the most cumbersome tool that we have. And why? Because we have a Bill of Rights. And we like to think of them as a Bill of Rights. They are, in fact, a Bill of Liberties. Not a Bill of Rights, a Bill of Liberties, so the rich and the powerful can get off. Who were our founding fathers? They were smugglers. They were land fraud cheats. They were tax evaders who did not want to own up to what they should have owned up. The French and Indian War was fought by whom? For whom? By the British to protect the American colonies from getting scalped. We got the benefit of the war, but we weren't willing to pay taxes for it. And that's a British perspective, but it seems to me to be an accurate statement of the situation. We want government services without taxation. Does that sound familiar? How many people here expect to collect Social Security? Right? The older people are ripping you off right now. I'm on Medicare. Why should I be on Medicare? I can afford to pay my own bills, but I'm going to get you guys to pay for them, right? The old folks are manipulating the system to take care of themselves. When are we going to wake up and look how the laws manipulate various populations and make a judgment about this side is good, this side is bad, and move them back? We have to do it. If our founders were smugglers and tax cheats, what happened in the 18th century? The 17th century is the first. Well, everybody's proud of the railroads, right? Everybody's seen the driving of the Golden Nail, and they both left this. Do you know what the real story behind the railroads were? I'll back up a little bit. We had a canal, the Erie Canal, and the people who were sponsoring the Erie Canal went down to the Southerners and wanted to hire the slaves to do it. And the Southerners said, they're too valuable. Why don't you get the Irish? Okay, and the Irish guys got off the boat, and they're the ones who built the Erie Canal and suffered all the pain and suffering associated with it. When it came time to build a railroad, it was the Irish people from east to west. Who was it from west to east? The Chinese. And you know why they had Chinese do it? Because it didn't make any difference if they blew themselves up as they went through the mountains with dynamite. Have you heard that as part of the railroad stories? Not really. This was a glorious thing. Do you know, as a practical matter, that every single one of those railroad companies went bankrupt? They all went bankrupt, which meant the bondholders, this part doesn't bother me, most of them were from England. And so anything you could steal from the English, they don't deserve to have anyway. And that probably wasn't a bad idea. What they did is they had a railroad company, and then they had building companies that ran alongside it. And the building companies sucked out all the profits and left the railroad companies to handle on their own. Where do you think Stanford got all the money to build Stanford? Where do you think Harriman got all the money to later become a great man in our society? They stole it from the English bondholders. How about oil? How did we develop our oil system in this country? Who did it? Maybe some of you actually remember the name. Rockefeller. And how did he do it? By suppressing all of the competition. The Sherman Act was passed to get Rockefeller. And it took from 1890 to 1910, 20 years to break up the Standard Oil monopoly. Now, it broke up the monopoly, but did it get any of that money back for the victims of the antitrust behavior? Did it get any of that money back from the Rockefeller family? Not really. We had steel in this country. We made steel. We made steel so the railroads would go. We made steel for the bridges. And who made that steel? That was Carnegie. And who suffered in the making of steel, working 12 to 14 hours? Basically in an oven. And when you went on strike for lower hours and working conditions, he brought in the Pinkertons and proceeded to kill the strikers. These are our parents, right? Most of the money, collective money in the 1%, is inherited money, not earned. It's inherited. And how was it gained? By smugglers, sweatshops, and so on. Well, as a result of the 20s scandal, we created some institutions. We put in some securities statutes, which the securities industry opposed, which the accounting industry opposed. They said grass was going to go on Wall Street. And all we put in was a definition of securities fraud taken from English law, and they objected to that. We created the SEC so there'd be a cop on Wall Street. Good idea. But who appoints the cop? The people in charge in the government. And what you do is if you don't like the cop, you capture the government. They used to say the largest single explanation for organized crime was public corruption. The largest single explanation for white-collar crime is not public corruption directly with bribery, that's too crude. It is with campaign finance money. You buy the government, pure and simple. You buy the government, and you get a compliant government. Cox, the right-wing Republican congressman that put the 95 Amendment in, became the chairman of the SEC. And what did he proceed to do? To gut it. Insofar as it did major cases, it had them make petty cases, and they met less of those cases. And the best people at the SEC left. That's what happened. We didn't have a cop on the street. We used to have a statute called the Glass-Steagall Act. One of the things they did in the Depression is they created depositor insurance. So the little people who put their money in and it went under could get back from the government, deposit insurance. That meant that the banks had a large pool of insured money. And what they did in the Depression era is they said, you can invest and speculate with your own money, but not the people's money. They just repealed the Glass-Steagall Act. And now that we had Dodd-Frank, but does it restore the Glass-Steagall division? No. And what does that do for banks? Banks have large amounts of money that, because it will result in a loss to the FDIC, they become too big to fail. And because they're too big to fail, they can charge less entrance and make money. They are in illegal competition, quotation marks, with all the other banks. And they're too big to fail. So they hold us up. And do we get to regulate them more? No, this is called socialism for cost and capitalism for profits. Isn't that great? You guys are going to be lawyers. You're going to have to collect your fees one day. How would you like the government to socialize your expenses and let you have the benefit of your fees? You really ought to have one or the other, but not both. It's been carefully designed so we have both. So we're now in the 21st century. I am a pessimist. I don't think it's going to get any better for a variety of reasons. One is we've lost our Judeo-Christian heritage and carried with it our sense of right and wrong. Right is not what you do in the sight of God or what you don't do in the sight of God. It's what you can get caught for and not. And you're not worried about an afterlife. It's today only, which means the criminal justice system cannot presuppose a basically law-abiding public. The Protestants were all uptight about some things. And what did they do? Not good immigration laws. And all the Italians and all the Jews came over and did what? They substituted for the Protestant ethic the Catholic ethic, the Jewish ethic, or maybe no ethic at all. That's how we have moral pluralism today. And when you have moral pluralism, you don't have any agreements on morals, in which case each person is allowed to decide it on his own. You even have philosophers, such as Nietzsche, that says that's the right way to do it. Right because you make up your mind what's right and wrong. We're not going to roll that back anytime soon. I'm not sure we really should. Because of technology, it's not only electronic technology, it's also social technology. The Egyptians were able to build the pyramids because they could organize the people. And instantly they were not slaves. They worked 6 months of the year building pyramids. Then they did, and then they rested. And when they worked 6 months of the year tending fields. Then the other 6 months they worked for the king in building him a place to rest. And that was thought to be a good idea. They had a social organization. A social organization is a form of technology. Our social organizations include churches, unions, not so much unions anymore, we run the unions off, large corporations. And they're not just large corporations subject to our jurisdiction, they're multinational corporations. They make money, but what do they do with it? They attributed it by accounting to offshore corporations, so they don't pay our taxes. Apple went in and admitted to the Senate committee that this is what it was doing. The most wealthy corporation in the world paid virtually no income tax because they had put it offshore. Now, is that illegal? No, it was technically illegal, but who created the laws that said that that was illegal? The lobbying groups. The reason we have frequent tax revisions is the people who sit on the finance committees get to ask for more contributions because they're working on a tax law. That's not going to change. We also have found that if we put together government in organizations to chase the bad guys, those government agencies can be seized and controlled. This is a day-to-day presupposition for people who look on how government agencies work. And you don't have to corrupt them. You just have to incentivize them in their investigations. That'll do it. So our government agencies don't work anymore. And our laws, principally the criminal law, was designed for a single offender who committed an antisocial act on a single day, in a single time, in a single place. And that's what goes to trial. Organizations are not part of the discussion. Those people are relatively easy to investigate. Guy walks in a room, throws a woman down, rips her blouse off. That's assault with intent to rape, isn't it? You don't have to get a confession. You just put the evidence in. Let me give you a different situation. Let me give you receipt of property, stolen property. When you receive stolen property and you're in a business context, you're constantly receiving stolen property. How do you tell receipt of stolen property from receipt of property? The only way you can do it is by showing state of mind. You have to prove state of mind in the case. You don't have it screaming out from the facts. This is like how do you prove that a corporation or a conspiracy occurred? You can bug the people discussing it. Let's put a device in. You can put a wiretap in. You can put an undercover agent in, become part of it. Or you can flip one of the two people by turning them against the other people. You can do it with circumstantial evidence, but it's just, might as well forget it. Bug B or turn. It's only three ways. Do we do regularly bug B or turn against white-collar offenders? No, that's the investigative techniques we use against drug dealers. I'm all for giving the white-collar offender the constitutional rights of drug dealers. Yes, yes. I'm believing that we ought to punish drug dealers just like, or ought to punish white-collar offenders just like we punish drug dealers. I'm not in favor of mandatory minimum sentences. I think they're unconstitutional. But I am in favor of a sentence against anybody in the hierarchy who is culpable for doing the behavior or not preventing it when they had an opportunity and the power to do it. They ought to have jail time. Not 50 years. 2 years would be fine by me. Would that deter the individuals? Not that much unless they think they're going to be investigated and caught. Deterrence, which is I'm talking about, is swift, sure, and severe justice. That's the formula. I can't put numbers in the integrals because I don't have enough information. But I know if you don't bring cases at all, there's no deterrence. Why do corporations fight criminal charges? Because they don't like to be convicted. If they don't like to be convicted, that's a stigma that we can use against them in order to deter crime. If all they get is civil fines, and the civil fines are less than what they made in the profitable transaction, they're all sitting there with no morals, and they're calculating, how much can I make? How much can I lose? I'm not going to do jail time. The lower level people will. Do you think Jamie Dimon's worried about going to jail? Do you think he's actually worried about paying over additional money? He got a raise, right? Why does he get a raise? Because he appointed the board that sets his salary. And what do? They look to other large organizations for comparable salaries. The salaries of the major corporations in this country are 10, 100 times what the people who work in them are. Ask sometimes what the ratio is in Japan. It's not even night and day the thing. What do they do with the money? You can only buy one car to drive at a time. You can only really live in one house at a time. Do you really need a boat, an airplane? They asked McCain how many houses he had, and he didn't know. Is there anybody in here who has more houses than they know that they have? Well, the answer is the money. It's not that you have to strip the rich down where they don't have anything, but why should a person live in a box in Chicago in this kind of weather, and the people at the top live in the kind of wealth that they live in? I find that obnoxious. Are we going to change that? No. So what am I suggesting is happening? What I'm suggesting is happening is the very rich have had it all for a long period of time. They have been free of accountability for a long period of time. Not everyone all the time, but largely free of accountability. That's not going to change anytime soon. We should make every suggestion that was made in here as incremental steps to try to make the system fair, more fair, and have everybody subject to a criminal sanction. Appropriate. Everybody having them applied to them. What I did and got away with when I was a teenager was related to my socioeconomic class and color. And it should not be that. I'm in favor of holding everybody responsible, not just the poor, not just the disadvantaged, but everybody. Some people have asked me whether RICO, the statute, was named after the character in Little Caesar that was roughly aimed or roughly built around Capone's rise. And I decline the answer to that question on the grounds it might tend to incriminate me. But I will say that RICO was designed to change the outcome of the situation in Little Caesar. Little Caesar was shot in the alley. I don't think that low-level criminals or organized criminals ought to be shot in the streets. Bring them in, give them a trial. But the point of Little Caesar is Big Boy, the guy who was behind the little Italian immigrant, never had any sanction by anybody. He wasn't shot in the alley, wasn't shot at all. So the movie was designed to change the result. Give Enrico Bandello a fair trial and lock him up. And give Bad Boy a fair trial and lock him up. If that would happen, we'd have justice for all. Thank you. And that's the last word. right?
Professor, do you have time to answer a few
Sure, always.
If anybody has some questions, give some time.
Don't be intimidated. You know, it's all a nonsense that I intimidated students. That's a myth told by upper-class people to scare the first year. There's no truth in it. Ask Sarah. Is it true that I beat people up in class? Pardon? Oh, all right. Any questions? I take it by your silence. This is a fundamental principle of the common law, that silence equals consent. This was Thomas More's defense. I never said anything about the king. And he'd have gotten away with it if Richard Rich hadn't come in and perjured himself and said he did say something. So by not asking questions, you're consenting to everything I said. Thank you.
Please join me in thanking Professor Blake. Everybody would like to join us. We have a reception in the conference. And thanks again to our morning panelists.
Campaign finance is so real. Like if we could make that completely public and not allow.
Everybody gets to put in $5,000 and nobody gets to put in any more.
Yeah.
Money ought not to equal voice.
Exactly.
The notion that a corporation is a person is obscene. Now, get this. It's a person for jail. It's a person for the person. Oh, no, there's plenty of time. There's plenty of time.
I just wanted to say hello, welcome back. Amen.
I'm going.
Amen.
Amen. I'm going.
For sure.
Are you kidding? Yes. Yes. I was raised in the South. I've heard Baptist preachers. Yes. And I was raised in a Protestant church called Catholic. We couldn't dance. We had a choir that did all that for us. Look in this guy. I'm talking about the ones who left and announced it. The official acceptance. You include the ones in the pew. How much Robert's about? Yes. Yes. He even got a podium. Who am I? Hey, who am I to judge? Hey, who am I to judge? That's not what Benedict said. Yeah. Yeah, even if they're lepers. Yeah. Just sort of like Christ did. And it was spontaneous.